My name is Mickey Collins, representing Veritex Legal Solutions. The date today is May 23rd, and the time is 10:04 a.m. This deposition is being held in the office of Collins Real-Time Reporting, located at 1700 Pacific Avenue, Dallas, Texas. The caption of this case is Krista Surovec et al. Versus L.A. Dunwoody versus L.A. Dunwoody LLC et al. In the State Court of DeKalb County, State of Georgia. Case number 10A32103-3. The name of the witness is Bruce Jacobs. At this time, will the attorneys identify themselves and the parties they represent, after which our court reporter, Larissa McPherson, representing Veritex Legal Solutions, will swear in the witness, and we can proceed.
My name is James Potts, here on behalf of Ms. Surovec.
I'm Brian Neary, here for the defendants.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Would you state and spell your full name, please?
Sure. Bruce Jacobs, Jacobs.
Thank you.
Just before we get any further, he'd like to read and sign the deposition.
That'll be fine. And any notary's fine. Mr. Jacobs, in the past year, as a testifying expert in a jury trial, how many verdicts of $25 million or more are you aware of?
None.
Okay, none in which you've been a defense expert.
Correct.
Okay. Do you recall a case, Leonardo Davis versus Corpus Assets LP et al.?
No.
Okay. Have you ever testified in Nueces County, Texas?
Probably.
Okay. Have you ever worked with David Brothers?
Yes.
Okay. That's at Brothers Sepulveda and Alvarado in Houston, Texas?
Sounds vaguely familiar.
All right. And you don't recall testifying in a case entitled Leonardo da Villa versus Corpus Assets LP?
Yeah, da Villa, yes. You said Davis before.
I think Leonardo da Villa versus Corpus Assets LP?
Correct.
Do you recall being a defense expert in that case?
Yes, sir.
And your opinions, to summarize, as the defense criminology expert, you testified that the security was adequate and there was insufficient crime on the property to warrant the security measures that da Villa claimed were needed. True?
I'm not certain. Da Villa was a security guard who patrolled the perimeter of the building. And in the 10-year history of that building, there had been 0 violent crimes, and he was attacked one night.
Right.
And that was the source of the lawsuit.
Right.
Was a security guard saying that there was inadequate security.
Right. And the jury returned a verdict on May 30, 2013 of $25 million. Isn't that true?
It may have been correct. I was retained by the owner, and the owner was found 0% liable.
Okay. You were the only security expert in that case, true?
I can't speak for the other defendants. I was retained by the owner.
And tell me what other security experts you recall in that case.
I don't know, sir. I just did my job.
Okay. But thank you. You answered that question. My question was a little different. I want to know what other security experts you recall that testified in da Villa versus Corpus Assets LP.
For the defense?
Yes.
Or for any party?
For the defendant.
I don't
any
recall.
defendant. All right. You don't recall any as you sit here?
Correct.
All right. You agree that parking lots are one of many known venues for predatory violence, true?
Among many, sure.
You agree that parking lots are one of many known venues for predatory violence, true?
Any venue can be any setting can be potentially a venue for predatory violence, correct?
Okay. And I get that any setting can be a venue for predatory violence. My question is really just this: whether, in your view, parking lots are one of many known venues for predatory violence.
Asked and answered.
You may answer.
Again, I think I answered the question. Crime knows no address. It can happen anywhere, anytime, especially predatory crime.
Right.
So certainly, parking lots, malls, grocery stores, apartment complexes, transit stations, these are all potential venues.
Okay, including parking lots. True?
As I just said, yes.
Okay. And that would also include covered parking garages, true?
Just like any other address. Any place in America potentially can be an address of predatory crime.
Right. But we're not, I mean, I'm not talking about any potential address. Are you familiar with the address 1850 Cotillion Drive in DeKalb County, Georgia?
Yes, sir.
And that's the address where Nicholas Surovec was murdered, true?
Correct.
And that was in a parking garage at that address, true?
Correct.
And in fact, we have over 80 reports, a number of which we'll get into in a moment, you haven't been provided with. But the address of the crime in each of these reports is 1850 Cotillion Drive,
Object to the form
DeKalb County, Georgia.
Excuse me. Object. I'm sorry.
That's fine. Go ahead. Say whatever you...
Object to the form of the question. Assumes facts, not in evidence.
All right. I'll begin again. What was... You mind reading back my question, please, Madam Court Reporter?
And in fact, we have over 80 reports, a number of which we'll get into in a moment, you haven't been provided with. But the address of the crime in each of these reports is 1850 Cotillion Drive.
DeKalb County, Georgia.
You said that I haven't been provided with?
Yeah. Yes.
Have not been provided?
Have not.
I'm not sure what you mean.
Well, first of all, the address of Nicholas Surovec's murder is 1850 Cotillion Drive, true?
Yes.
His murder does have an address, true?
Yes.
It's 1850 Cotillion Drive, DeKalb County, Georgia, true?
Yes.
So crime in this case, it does have a very specific, precise address, and it's 1850 Cotillion Drive, true?
Certainly.
Okay. You agree that, like a meteor falling from the sky, violent crime can happen at virtually any time or place, true?
Correct.
If a lion was released by a zookeeper at a zoo and that lion mauled and killed someone, would you hold that lion responsible or that zookeeper responsible?
Object to the form of the question. Argumentative.
You may answer.
I'm really not sure. I'd have to really think long and hard about the nature of that question, given I'm not a zoo expert.
Take your time.
I need more time than you're going to give me, sir.
Well, no, I'll give you all the time you need.
Okay. Can you restate your question?
Would you read it back, please, ma'am?
If a lion was released by a zookeeper at a zoo and that lion mauled and killed someone, would you hold that lion responsible or that zookeeper responsible?
Object to the form of the question is argumentative.
Yeah, I'm not a zoo expert. I can't answer that question.
Okay. And if at any time you don't know the answer, just tell us you don't know. Do you believe that Nicholas Surovec was in any way responsible for his own death?
I'm really not here to talk about responsibility. That seems to be a legal opinion that I don't offer opinions on.
Mm-hmm.
It seems to me the province of a jury, not mine. So I really didn't address that in my opinions.
But that's my question for. I'm entitled to a thorough and sifting cross-examination. They've called you as an expert in the murder of Nicholas Surovec's case, which we'll be trying. The trial starts on the 9th. So I'm entitled to ask you questions,
Sure.
and I'd like for you, Madam Court Reporter, would you read that question back again, and I'd like an answer from you.
Are we going back to the zookeeper?
No, ma'am. The last question about Nicholas Surovec, in any way responsible for his his murder?
Do you believe that Nicholas Surovec was in any way responsible for his own death?
I have no opinion on that.
Okay. Do you believe Nicholas Surovec played any role in his own death?
I know what the criminological evidence says about the relationship between victim resistance and robbery and homicide.
Right.
Other than that, I don't have an opinion.
Okay, well, the other than that part, well, tell me which part you do have an opinion about.
I don't have an opinion on Mr. Surovec's responsibility for his homicide. I don't. I wasn't offered or asked to offer that opinion.
Right.
I don't have an opinion on it.
All right.
I can just tell you what the criminological data says.
All right, and that says what?
Essentially, if a victim resists during an armed robbery and there's a firearm involved, you're essentially 16 times more likely to be killed than somebody who doesn't resist.
Right.
That's just a criminological data point. It's not an opinion.
And did, in your view, Nicholas Surovec resist at all?
It's not my opinion, but the scholarship and the conceptualization surrounding victim resistance would count that as resistance.
Would count what he did as resistance?
Correct.
And what did he do that would be counted as resistance?
He bucked the robbery, and I don't have an opinion on blameworthy or responsibility. That's just he resisted the robbers during the offense and was shot.
How did he resist the robbers during the offense?
Apparently he got into an altercation with the offenders, according to his wife.
Based on what do you base that testimony on?
His wife.
Okay, and which portion of her testimony?
Where she says she looked back and she observed a fight or altercation between the victim and the offenders.
Right, and you don't know how that altercation began, do you?
Correct.
So why would you suggest that Nicholas Surovec, started or played a role in the start of any purported altercation?
Well, I never said that, sir.
Okay.
I never said that.
Then what role did he play that would make Nicholas in any way responsible
Object the form.
for his own death?
Excuse me.
Okay.
Object the form that he already.
Yeah, I told you I'm not opining on his responsibility.
Okay.
I just related a criminological data point
Right.
that you asked me about.
Right.
I'm not opining anything whatsoever about his responsibility.
Right. Well, but you said, or you suggested that he somehow resisted, or the word you used was buck the robbers. Well, how did you arrive at that conclusion?
Based on his wife's testimony of an altercation, conflict between the victim and the offenders as they proceeded to the apartment.
Right, and what makes you testify under oath that that originated with Nicholas Surovec as opposed to a robber?
I didn't say that. I said that there was resistance.
Okay.
Where it emanated from is unknown, but that's resistance. Criminologists would call that resistance.
Criminologists would call what resistance in this case?
Fighting with an armed offender during an armed robbery.
Okay. Have you ever had a gun put to your head?
Yes, in fact, I have.
Okay.
Not to my head, actually. I think it was to my torso.
Yeah. And how did you respond to that?
I gave the offender exactly what he wanted.
You didn't resist at all, true?
No, sir.
I've got a book, Investigating Deviance and Anthology. That's you, Bruce A. Jacobs, right?
Correct.
Mark this as Exhibit 2 through Deposition. Now, there are a number of articles in here, but you only wrote one of them, true?
Yeah, that's an edited collection. It's called an anthology, which is a collection of other published works that you write introductions for.
Right.
And it's a standard instructional text in my discipline.
An article you wrote was Researching Crack Dealers, true?
Yeah, that comes from my book, Dealing Crack,
Right.
published in 1999.
But the article in Investigating Deviance and Anthology by Bruce A. Jacobs, that's you, is entitled Researching Crack Dealers, true?
Okay, if you look more carefully at the article, you'll see it's adapted from my 1999 book, Dealing Crack, published by Northeastern University Press. So an anthology is a collection of previously published works.
Right.
And that's one of them.
Okay. Yours is item number 16, which is Researching Crack Dealers, true?
Correct.
And when you were researching crack dealers, you actually had a crack dealer place a gun to the right side of your abdomen, true?
Correct.
And you responded to that crack dealer with a loaded .45, and I'll quote you, "What the fuck's your problem?" Close quote. Isn't that true?
Correct.
Okay. And you weren't killed?
Correct.
Do you consider that resisting?
No.
Well, why didn't you tell me that a moment earlier? Do you believe that saying "what the fuck's your problem" is tantamount to your under oath testimony a moment ago where you said, I gave him whatever he wanted?
This is a person I had known for many weeks who was my principal field worker
Right.
on that project,
Right.
who, unbeknownst to me, essentially turned on the project and turned on me and put a weapon on me and demanded money. So this is not a predatory stranger-on-stranger victimization, the kind that seems to anchor this case. This is a person that I had known quite well, who had served as field worker for many weeks, who had provided me many, many respondents without problem, who
Right.
called me one day, brought me down to the hood, and put a gun to my abdomen.
Right.
So that's exactly why I said what I said, because this is a person I had trusted.
And what you said was, what?
You read it. I'm not going to swear for the deposition.
What do you mean not? You just don't want to repeat what you said?
Correct.
All right. And, I mean, just reading your article, subsequently you said, "Don't shoot, I'll give you what you want," true?
If that's what it says, that's what I said.
Well, I mean, this is what you wrote. I'm not...
Sir, this happened 15 years ago, actually close to 20 years ago, but if that's what it says in the article, that's what I said.
Okay. And on reflection, you would not have said, "What the fuck's your problem," true?
I don't think I ever said that.
You don't think you ever said, "What the fuck's your problem"?
No, you said upon reflection.
You would not have said, quote, "What the fuck's your problem," close quote.
That's not true. I knew the guy. He knew me. He turned on me. He was a trusted informant. I was mad. This guy worked for me.
Okay.
And he was a big part of the project.
Right.
And he turned on it.
Right.
And I did say that, and I'd say it again.
All right. And that was, you were angry because someone pointed a loaded gun at you?
Correct.
All right. And would you expect someone to be angry if someone pointed a loaded gun at him?
If he had worked with the gentleman for weeks, if he had was a confidant in some respect, if he was a paid field worker for a project on a grant, if he had developed trust with that person, an internal connection with that person, absolutely. But absent that, that would be an unusual response during a robbery.
Do you agree that landowners have a duty to protect visitors from foreseeable criminal harm? True?
Correct.
And that includes parking garages, true?
It depends on the crime history of the property.
Well, landowners have a duty to protect visitors from foreseeable criminal harm, true?
Correct.
And if a landowner also has a duty to protect visitors from foreseeable criminal harm in that landowner's parking garages, true?
Assuming the crime is foreseeable, yes, sir.
Okay. You agree that crimes are foreseeable when the totality of the circumstances give landowners notice that such crime is likely to occur there. True?
That comes from an article I wrote detailing
correct.
the... I'm sorry?
That's correct.
Okay.
It does.
Can I finish?
Well, if you're answering the question, you may.
Yes, sir. That comes from an article I wrote that describes the different tests to assess foreseeability that courts around the country apply.
Right.
And totality of circumstances is one of those tests.
Right. And
Used by some courts around the country.
right. Do you know what the Georgia courts use?
I believe it's substantial similarity.
Okay. Have you read cases and on premises liability in Georgia?
Yes, sir.
Which ones have you read? I'd like for you to list them for me.
Sturbridge comes to mind. I believe that's the principal Supreme Court case
Right.
that talks about substantial similarity. That's the one that comes to mind first.
Okay. Any others?
Not as I sit here.
Do you agree that foreseeability requires that the general danger be foreseeable as opposed to the exact sequence of events that produce the harm? True?
That's what some courts have said, yes, sir.
Okay. And you agree with that? True?
Well, it's what some courts have said. So, some courts believe that is true. Yes.
Right? Do you believe that's true?
Possibly. It depends on the circumstances.
What do you mean, possibly? When would... What do you mean, possibly?
Could you reread the question, please?
Sure. Could you read it back, please, ma'am? I'll get it. I'll save time.
Well,
I'll do it.
let's just get the exact question back.
What's that?
He wanted the court board to get the exact question.
That's fine.
Back to him.
Do you believe that's true? Is the last question I have. Before that, and you agree with that, true? Before that, do you agree that foreseeability requires that the general danger be foreseeable as opposed to the events that produce the harm? True?
Well, I don't think anyone ever looks for identicality. That being said, when I assess foreseeability or the probability of an event occurring, I typically look at reasonably similar crime. That's what criminologists look at to try to forecast future crime, especially when it involves a predatory act of robbery homicide.
Mm-hmm. And Nicholas Surovec was murdered, true?
Correct.
He was murdered at 1850 Cotillion Drive, true?
Correct.
He was murdered in the parking deck at 1850 Cotillion Drive, true?
Yes.
And what appeared to be armed robbery, true?
Yes.
Do you agree that defendants should be required to protect patrons from most criminal behavior?
Say again?
Would you read it back, please, ma'am?
Do you agree that defendants should be required to protect patrons from most criminal behavior?
Defendants should be required. I don't think I agree with that.
Okay.
Depends on the nature of the criminal behavior. Depends on the foreseeability of the criminal behavior. It depends on the nature of the protection that is required to prevent that criminal behavior.
Okay. Have you ever heard of a publication called For the Defense?
Yes, sir.
And you've written articles for that publication?
Correct.
And For the Defense is a publication that's used by defense lawyers, true?
As far as I know, yes, sir.
It's and defense lawyers would be the ones representing the defendants, the property owners, in Nicholas Surovec's case, true?
Presumably.
Krista Surovec's case, true?
Yes.
And you wrote an article in April 2004, Premises Liability and the Undeterrable Offender. Do you recall writing that?
I do.
And the basis for that article was foreseeability and premises liability, true?
No, the basis of that article was the concept of deterrability.
Okay. Did the publication write this, or did you? I'm just looking at, I'll go ahead and mark this too.
The publication appeared to write that title. I wrote the title of The Undeterrable Offender.
Okay. Make a note, we'll make a copy of For the Defense, Premises Liability, and the Undeterrable Offender. Make that Exhibit 3 to Mr. Jacobs' take a deposition. just show you what is page 17 of Exhibit 3 to your deposition, the article that you wrote entitled The Undeterrable Offender. And it reads, in pertinent part, the theory discussed here is that, comma, while the defendant should be required to provide security to protect patrons from most criminal behavior, the defendant cannot be expected to respond effectively to criminal behavior that cannot reasonably be deterred. Did you write that?
Can I read it first?
Sure.
Is there a earlier part to this?
What do you mean an earlier part?
Is this the first page of the article, or is there another page?
It's the first page that, let's see, we've got an introductory page, which by Bruce A. Jacobs begins over 30 years ago.
Right, the prior paragraph talks about foreseeability.
Correct.
The paragraph that you read transitions from the foreseeability paragraph into the sentence that you wrote. So in the context, it's talking about foreseeable crime.
Well,
not any crime,
right.
Foreseeable crime.
Right, I read it, you wrote it, right?
Well, I wrote the first paragraph
I
too.
think you just misspoke when you said I wrote it instead of read.
Right.
I'm sorry.
That's all right.
He meant to say, yeah.
Yeah, the first paragraph that I wrote talks about foreseeability.
Correct.
The second paragraph transitions from foreseeability into deterrability.
Right.
And so the implication of the second paragraph is criminal behavior must be foreseeable to warrant protections first.
Right. The theory discussed here is that, comma, you wrote that, right?
Recognizing there is a paragraph talking about foreseeability immediately before this paragraph.
Right.
Correct.
While the defendant should be required to provide security to protect patrons from most criminal behavior. You agree with that, true?
Assuming it's foreseeable based on the previous paragraph.
Right.
Yes, sir.
Right. Do you agree on some level any crime is foreseeable?
Crime can happen anywhere, anytime. So theoretically, crime is foreseeable anywhere.
Right.
So the question is, when you telescope to a particular property, how foreseeable is that offense based on prior incidents there?
You would agree that on some level any crime is foreseeable, true?
Given the context that I just provided in the previous answer, yes.
You agree that foreseeability comes down to assessing prior patterns of crime at or near the premises to gauge the yet to be committed crime, true?
Typically that is true.
Okay. And that's true in this case too, true?
I would imagine, yes, sir.
Okay. You agree that, quote, obviously, the greatest liability accrues to landowners that fail to take reasonable measures when the burden of doing so is light and the foreseeability of harm is high, and when the potential magnitude of the harm is great. True?
Yes.
You agree that defendants, like Elad in this case, typically try to whittle down the type and number of previous crimes to show the aberrant nature of specific harm. True?
Some defendants do that, sure. Some don't, some do.
Well, what you wrote was, quote, defendants typically try to whittle down the type and number of previous crimes to show the aberrant nature of specific harm, close quote. True?
Well, of course, I didn't write the article in the context of an interrogation like today, but again, some defendants do, some don't.
Some defendants, well, typically they do, right? That's what you wrote.
That's what I wrote.
And that's so jurors don't get to see necessarily all the crime that occurs on a particular property. True?
Objective form, just to the extent you're calling for him to make legal conclusions. Actually, a lot of these questions are asking to do that. So I just want to state that objection.
Yeah, I can't speak for the legal strategies of other hypothetical defendants.
Okay. Well, what is your view about why defendants typically try to whittle down the type and number of previous crimes to show the aberrant nature of specific harm?
I would say that the preeminent reason is for precision, to recognize that public intoxication, loitering, speeding, relatively minor public order crimes don't necessarily predict robbery homicides. And so that's what the statement means.
Mm-hmm. That's from your article, Foreseeability and Duty of Care and Third-Party Premises Liability. True?
I would assume so. It sounds familiar.
Okay. You agree in a case like this, apartment burglaries are relevant analytic considerations?
Apartment burglaries? In this case?
Yes.
Absolutely not.
Okay. Is this, do you have a Wi-Fi connection? Do you know the Wi-Fi connection?
There's Wi-Fi there.
What's that?
There is Wi-Fi in here. But I can't tell you.
I'm sorry, I couldn't hear you.
I can't tell you what the password is.
What is it?
I think it's just
CRR
Yes.
guest. Do you know the code for it?
No, I haven't got on.
I'm gonna need
On
to
the
get
net.
that. Yeah. I'm gonna get the Wi-Fi password. I'll be right back.
Go off the record.
Yeah, let's take a quick break.
Going off the record at 10:37 a.m.
I'm just gonna be.
We're on the record at 10:41 a.m.
You agree that a property should not have a porous perimeter?
Object to the form.
Can you read from the article that or can I see the article you're quoting?
Well, this is not from an article.
I think it is, but
Well, part of it is, but
it depends on what you're trying to be porous from.
murderers.
Do they have an internal connection to the property? Are they trespassers?
Does that make a difference about whether you ought to have a porous perimeter?
Well, certainly. If they have an internal connection to the property, porosity means nothing.
Okay. So if, for instance, someone lived in the property and had access to all of the, I guess, apartments and parking garage, then porous perimeter would make a difference. Is that right?
Among other scenarios, certainly.
Okay. But assuming that weren't the case, you would prefer not to have a porous perimeter, true?
Depends on the property.
Okay, tell me when you would want to have a porous perimeter.
Well, obviously, if you're a supermarket and you need people to have access to your business, you want access to be readily available.
Right.
You're not going to put gates and fences and high-speed control arms and barbed wire and a whole host of other measures to prevent access. So in that sense, porosity is not a negative.
You mean
in a prison, you obviously want it impervious to essentially both entrance and exit. So it depends on the property.
Right. Well, Nicholas wasn't murdered at a supermarket, true?
Correct.
He wasn't murdered in a prison, true?
Correct.
Wasn't murdered in a jail, true?
Correct.
And even a supermarket, if you have a place for your patrons, and if you have another place where you don't want people going, you would rather not have a porous perimeter, true?
Assuming it's a sensitive area of the store, certainly.
Right. And have you been to Madison Square, 1850 Cotillion Drive?
Yes, sir.
When did you go?
Can I see my file?
Yeah.
Sure.
This one.
We'll go ahead and mark that as Exhibit 4. Let's put it out here.
February 24th, 2014.
Okay, so this is May 2014. So it's 3 months ago?
Correct.
Okay. That was, let's see, Nicholas Surovec was murdered in October 2008, true?
Correct.
So let's see, October 2008, October 2009, 2010, 2011, 2012, 2013. So you first went to the property over 5 years after Nicholas Surovec was murdered, true?
Correct.
When were you first contacted about this case?
I believe January 2014.
Okay.
So about a month before my visit.
All right. So you weren't contacted until over 5 years after Nicholas Surovec had been murdered, true?
Correct.
Would you prefer to have been contacted much sooner?
I can't control when people contact me.
Yes, sir. And that's a little different. My question wasn't about whether you can control when someone contacts you. My question was whether you would prefer to have been contacted
I have no
much sooner than 5 years.
Either way.
Okay. You agree that most offenders are deterrable, true?
When you count loiterers and trespassers and drunks and vagrants and speeding violators, sure. When you count the whole universe of criminals, absolutely.
All right. And in fact, that's what you wrote, quote, most offenders are deterrable, close quote, true?
Including all offenders, the entire population of every type of criminal? Sure.
Okay. You also agree that risk-sensitive offenders generally are deterrable, true?
Generally speaking, risk sensitivity is associated with deterrability. Risk insensitivity is associated with a lack of deterrability.
Right. So risk-sensitive offenders generally are deterrable, true?
Generally speaking,
Yes.
yes.
You agree grossly insensitive to risk a potential perpetrator who's grossly insensitive to risk is not generally deterrable, true?
That's typically true.
Okay. And by grossly insensitive to risk, an example might be someone who actually rapes a woman. That woman, he doesn't have any issue with the woman, the victim seeing his face. He shares personal stories with the victim, things like that. True?
Leaves crime scene evidence, does it in front of a camera, does it next to a police station, does it in front of witnesses. Sure, those are all examples of gross insensitivity to risk.
Right. And of course, in this case, Nicholas was not murdered near a police station. True?
As far as I know, that's correct.
Okay. He was not murdered in front of cameras. True?
There were cameras on the garage, but not in the exact spot where the incident happened.
Right. And there was no one manning those cameras. True?
You mean like a physical person watching the monitor at the time? No.
Okay. And there was no sign letting people know that while no one's while this is a camera, no one's physically monitoring this. True?
I've never seen that, but I suppose you're right.
Okay. So the answer to that question, though, is there were no cameras in the area where Nicholas Surovec was murdered. True?
In the exact spot where he was killed? Correct.
Right. And in the exact spot where he was killed, it was 2:40 in the morning. True?
Roughly.
Yeah. It was dark out. True?
Well, it was dark outside, but the lighting conditions in the garage were outstanding.
Okay. The killers both wore hoods. True?
Yes.
They pulled them low across their face. True?
They wore them over their heads. I'm not sure if they were drawn all the way across their face, but they were definitely up, according to Ms. Surovec.
Right. According to the entire police homicide file, which we'll look at, no one was able to identify either one of the killers. True?
Well, there was nobody else in the garage but the two victims at the time, so that's probably why.
Which is another point. There was no one else around. True?
Correct.
That was what you might call a social deterrence. There was no, there were no other people around. True?
That's correct. There's no witnesses besides the two victims.
Right. And both the killers, they stayed behind the victims, Nicholas and Krista Surovec. True?
In what sense?
Well, they were lying in wait in the parking deck. They were about to get out. The killers closed the doors, forced them back into the SUV. They sat in the SUV behind them. They stuck the pistols in the back of their heads. They smashed out the rearview mirror. Isn't that all true? That's your understanding of how it happened?
Yeah,
true?
they definitely showed some planning in the execution of the crime.
Right.
They definitely showed some sensitivity, the fact they need to sneak up on their victims to get maximum surprise,
Right.
that they need to put them in a position of vulnerability. Yes, this clearly shows offenders who are bent on what they're doing. Absolutely.
So in your view, these folks were deterrable?
That's not what I just said.
Okay, they were not deterrable.
First off, I'm not offering an ultimate issue opinion in this case.
Okay.
So I will not be standing in front of a jury saying that these criminals were either deterrable or undeterrable.
Okay.
I will not offer that opinion. That's an ultimate issue jury question.
All right.
So I don't have an opinion with regard to that question.
Does that have anything to do with the fact that Judge Purdham's already ruled an opinion by you in that regard is not permitted in this?
No, that's pretty standard.
Oh, let me just finish. That's okay. I'll do it again. Does that have anything to do with the fact that our trial judge, Judge Purdham, in a previous case has already ruled it impermissible for you to testify in that regard as to deterrability or not deterrability?
That previous order, which I testified in front of Mr. Judge Purdham,
Right.
Who allowed me to testify to every other issue,
Right.
was about a rapist at an apartment complex and talking about his internal thoughts and processes, which, as far as I know, and no court in the land permits one to do.
Mm-hmm.
So it's very typical. The offender's name was Donovan Cross, and he was a rapist, and I couldn't talk about his internal thoughts and processes. So everything else I could. So no, it has nothing to do with that.
Well, yeah, you won't be able to talk about internal thoughts or processes in this case, true?
Correct.
I mean, you wouldn't know the killers if they walked in this room, true?
I'm not here to talk about the offender's mental processes at the time of the incident, no.
And you're not here, nor will you offer an opinion about whether they were deterrable, true?
Correct.
Okay.
My opinions will focus on essentially the adequacy and reasonableness of the crime prevention posture relative to the risk of this robbery homicide, and the lack of criminological predictability of robbery homicide based on auto burglaries.
Okay.
And in addition, I will talk about the functional limits of crime prevention using specialized criminological databases to offer that opinion.
Right.
And the reasons for the functional limits of crime prevention.
All right. We'll get to that. Now well, I guess what you're going to talk about is tools that you've developed, analytic tools to assess landowners' liability, true?
Could you restate the question?
Do you want her to read it back?
Please.
I guess what you're going to talk about is tools that you developed, analytic tools to assess landowners' liability, true?
I don't assess liability, that's the jury. What I do is I educate the jury about data, specialized data, data points, criminological processes that are relevant to assessing the adequacy and reasonableness of crime prevention posture relative to the risk of an incident occurring. That's my job.
Okay. I believe we talked briefly about an article that you'd written entitled Foreseeability and Duty of Care in Third-Party Premises Liability, published in the Brief, winter 2006, true?
Yes.
You wrote there, a number of analytic tools designed to more precisely assess the liability of landowners on whose property predatory criminal victimization occurs are available to bridge this gap. I mean, I'm not going to read the entire article, but when I did read it, my understanding was exactly that you were or had developed analytic tools to assess landowners' liability.
Again, I don't assess liability. I provide analytic tools for other people to assess liability.
Okay.
And that was the purpose of the article, among other reasons.
Okay, so when you wrote assess the liability of landholders on whose property predatory criminal, you weren't really assessing the liability of landholders. You were what?
Can I read the full context
Sure.
of the sentence?
And for the record, we'll go ahead and make a clean copy of Mr. Jacobs' article entitled Foreseeability and Duty of Care in Third-Party Premises Liability as Exhibit 5 to your deposition.
Thank you.
Sure.
The full paragraph says, too often litigators lack empirically defensible methods for determining whether a landholder has achieved the balance between risk and defendant's responsiveness to it. A number of analytic tools designed to more precisely assess the liability of landholders on whose property predatory criminal victimization occurs are available to bridge this gap. So again, I'm not assessing liability. I'm providing analytic tools for other people to do that. Analytic tools such as databases, criminological research, data points, criminological processes, all of which are relevant to educate people as to issues of risk and reasonableness.
Jim, you said you're going to we'll make a copy of this at the break.
Well, not one with my notes in it, but
Well, you just use it as an exhibit, so whatever you're using as an exhibit, we need to make as copies.
No, I'm absolutely not required to do that. I mean, I can show them a document and not make it an exhibit.
Well, you said
I said that I would make a clean copy. We can read it back. A clean copy, an exhibit. I'm not going to make my copy with notes and exhibit. So,
But you don't have the exhibit that we're actually using here at the deposition?
what I'm using is in my notebook. If you want to pull a copy and make one, then you can do that.
If you would, just so we can take a look at it real quick. I mean, I don't need to see your notes. I just want the name of the article.
Well, I mean, you want me to give it to you again now?
Yeah, if you don't mind, just the name of the article.
Sure. Foreseeability.
I can easily provide a clean copy for you.
Yeah.
Okay.
We've got it in the record
Good
many
enough.
times.
All right.
It's Foreseeability and Duty of Care and Third-Party Premises Liability by Bruce H. Jacobs. It's in the brief, winter 2006.
Thank you.
Sure. Wait, thank you. Yeah, fine. You wrote, as you read a moment ago, litigators lack empirically defensible methods. So what you're trying to do is helping defendants like Elad come up with empirically defensible methods.
That's incorrect, sir.
Okay. Then
That's incorrect. Empirically defensible means using actual data as opposed to speculation to provide a factual basis for an opinion or a position. And litigators is both plaintiff and defense. It does not say one or the other. It's both. And the point is to bring these criminological tools into a forensic setting to help everybody attempt to make more sense of the facts at issue.
you agree that the greater the natural surveillance at the time of the crime, the more deterrable the offense?
Holding everything else constant, all other factors constant, that's generally true. There's, of course, numerous other variables that are in play, but all else being equal, all else hold constant, yes.
And you agree security measures are effective? True.
It depends on the crime that you're trying to inhibit and the offender that you're trying to inhibit.
You recall, again, the article you wrote for the defendants, April 2004, premises liability and the undeterrable offender, beginning at page 16. At page 19, you wrote, most offenders probably are deterrable, and if deterrence is indeed the reason they refrain from offending, security measures are effective. True?
Most offenders, meaning the entire population of criminals, everything from the speeding violator to the loiterer to the vandal. When you include that entire population of criminals, yes.
Okay. And security measures are then effective. True?
Again, it depends on the nature of the offense and depends on the nature of the offender. So, when you're talking about petty, garden variety, non-violent, minor crime, that's a different animal than a predatory robbery homicide.
All right. Well, you wrote this article, and I'm going to read from your conclusion, and the paragraph reads, security operations, whether for parking lots, movie theaters, shopping malls, or hotels, are based on one simple and widely accepted belief, that offenders are deterrable. Period.
That's the belief.
Let me.
Yes.
Most offenders probably are, you wrote. And if deterrence is indeed the reason they refrain from offending, security measures are effective. That's what you wrote,
Oh,
true?
certainly. Everything in that paragraph is true.
All right.
In the full context, yes, sir.
You agree that deterrability is matching behavior to statements and assessing that behavior in context. That's all it is, true?
I wouldn't say that's all it is, but that's an important component.
Recall giving a deposition in Atlanta in a case Simona Edry, E-D-E-R-Y, versus Marta et al.
Vaguely.
Okay. At page 108 of your deposition, you were asked, question, are there any standards or practices within your industry to determine non-deterrability of an offender? Question mark. Your answer. Well, the issue for me is, would the offender have been deterred by reasonable measures? And that's what I have analyzed, and that's what the framework that I've given you is focused specifically on that issue. Not about, profiling or, some sort of checklist, period. It's matching behavior to statements and assessing that behavior in context. That's all it is. Is that what you testified to under oath in that deposition?
Recognizing that that offender was, I believe, imprisoned, and that statement that you're lifting refers to whether his conduct at the time of the incident for which he was imprisoned matched his rendition of his conduct in the cool confines of a prison cell years after the incident. That's what that statement refers to.
Okay. And we'll mark this as Exhibit 6 to your deposition. That accurately reflects your testimony, true?
Again, given the broader context of what I just explained, when you decontextualize that statement like you're attempting to do, it's very misleading, and I'm sworn to tell the truth, and I'm not going to mislead anybody.
Okay.
So that statement is in reference to the offender talking years later about what he would have done, which completely contradicted his behavior at the time of the incident.
Right.
That's what the statement refers to.
Right. And you didn't talk to either of Nicholas Surovec's murderers, true?
Oh, if I did, they would be in jail right now, wouldn't they?
Well, thank you. Answer that question. Would you read back my question, please, Madam Court Reporter?
And you didn't talk to Nicholas Surovec's murderers, true?
They have not been caught, so the answer is no.
Okay. So, but you were suggesting, and used a bit longer word, but that I was somehow taking your answer at page 108 in this deposition under oath out of context?
Absolutely, you did. Okay. Absolutely, you did.
And how is that?
I just explained it, sir. This is an offender. This question was about an offender who's saying what he would have done had a different array of security measures been in place, interviewed in prison long after he had committed the offense.
Right.
An offense I believe he was drunk and high on cocaine for, as opposed to the time of his prison-based deposition or interview where he was not high or drunk, he had adequate medical care, he was fed, he was clothed. And so that statement refers to the disconnect between an offender's statements about what he would have done and how he actually behaved on the day in question.
Right. And there's no way for you to determine any, quote, disconnect, close quote, because you have no idea who Nicholas Surovec's murderers are, true?
I'm not offering opinions on a disconnect, sir. I told you that I was not opining on the ultimate issue of deterrability. So I'm not offering that opinion, so I'm not sure, I don't understand your question.
Well, it's still, when you come to court and testify, we'll still be able to cross-examine you about the types of opinions that you render. So that's what we'll be talking
Oh, I
about.
understand.
Hang on, let me just state an objection to that question or statement that was just made, to the extent it calls for legal conclusions and decisions that ultimately be made by the court.
Well,
Right. That's fine.
I
Go
understand.
ahead.
I understand. I'm not offering that opinion, so I don't know what you want me to say.
Yeah, you're not offering an opinion as to whether Nicholas Surovec's murderers were deterrable.
Correct.
Okay. And so whether they were deterrable won't impact any of the other opinions you are planning to offer in this case, true?
I don't believe so. I think I've laid out my opinions in a succinct form, and I don't think they're related in that way that you're describing.
All right. You're prepared to give your full and final testimony here today, true?
Object to the form. Object to the form of the question.
You may answer.
Look, I mean, other material may develop. Other depositions might be taken.
Okay.
Other factual material might be provided. I, of course, reserve the right to review and analyze that material if it does arise.
As you sit here today, in your view, are you prepared to give your full and final opinion regarding Nicholas Surovec's murder?
Again, I think I just answered the question, and I don't want to be flippant about it. I'm just saying, if other things emerge that I have to analyze, I'm not going to be irresponsible and say I'm not going to do it.
Okay.
I will do it.
Did you read Tom Savoy's deposition?
I believe so.
Okay, would you pull it out, please? And for the record, we'll go ahead and mark as, we're going to mark, hold on, we'll mark this pile of, I guess, depositions as Exhibit 7. Okay. We'll mark your DVD as Exhibit 8.
I can see it in my stack here. Maybe there isn't. Maybe I didn't review his deposition. It's not in my stack.
Right. Any idea why you weren't provided with Thomas Savoy's deposition?
I don't know if there was one.
Wouldn't you, before you can reach a full and final opinion in the case, wouldn't you want the deposition of the security guard that was working and left not 40 minutes before Nicholas Surovec was murdered?
Well, object to the form of the question, though. That assumes facts, not evidence. That's not the evidence.
You may answer.
My understanding, sir, is that the security guard had left the night before. There wasn't a security guard on duty on the night in question.
Right. Well, you agree that there was no security when Nicholas Surovec was murdered, true?
There was no security guard at the time he was murdered, correct.
All right. Well, Thomas Savoy was the last security guard on duty before Nicholas Surovec was murdered. And he testified that he left at 2 a.m., which would have been about 40 minutes before Nicholas Surovec was murdered. Are you not aware of that before today?
Well, let me state it again.
There's a question for him.
Well, let me state.
You have an objection?
Yeah, I'm stating an objection to the form of the question. The court has already ruled that those facts are, that is not a fact, that he was there 40 minutes beforehand, that he was not there on the night in question. So I object to the form of that question, assuming facts that are clearly not in evidence.
Okay. Go ahead, you can answer.
My understanding, sir, is that this incident happened on a Saturday morning.
2 o'clock Saturday morning following, midnight Friday night.
Right.
Right?
And the last time the Crown security guard was on duty, I believe, was Friday morning. Around midnight, I believe.
So it left it, and let's get that clear, because there was some confusion very early on in the litigation, which is long since resolved. So is it your testimony that your understanding is the last Crown security guard left at midnight on Friday, between Friday and Saturday?
No, my understanding is that the Crown security guard was not on duty 40 minutes before your incident, and was probably not on duty for at least 18 to 20 hours before your incident. But again, this is what I've reviewed, and what my understanding that the court has determined about the timing of the prior security patrol.
And I need to know what you've been told in that regard, because the court made a determination. It's your understanding the court made a determination about when a security guard left before Nicholas Surovec was murdered?
I thought so. My understanding was that, and perhaps it's in some other testimony that I reviewed, one of the other deponents, that established that the guard was not on duty Friday night, Saturday morning. So perhaps I misspoke. Perhaps it was not the court. Perhaps it was another deponent.
So, but your testimony today is that you haven't reviewed Thomas Savoy's deposition transcript, true?
I can only review what is provided to me.
Right.
And so, if that was not provided to me, then obviously I did not review it.
Right. And his deposition was actually taken, let's see, on the 15th day of August 2011. Let's see, it's August 2012, 2013. I mean, at least 2 years ago. Any idea why you weren't provided with that deposition transcript?
It's possible I reviewed it and didn't print it. That's a possibility. I don't know. It's not printed in my file.
Right.
But it's possible I reviewed it on my computer and simply did not print it. I can't recall right now.
Well, according to what opposing counsel shared with us, which is a Dropbox link to what you were provided, it was not included in there. So that's commensurate with your testimony today that you didn't review it, and it's not in your stack of deposition transcripts here on the table.
It's not in my stack. It doesn't mean I didn't review it. That's what I'm saying. I could have reviewed it electronically. I just don't recall.
All right.
If he doesn't have it and hasn't reviewed it, I'm going to get it to him.
Well, the problem is, we need to ask him some questions about that after he's reviewed it. We've got a trial starting on the 9th, so I mean, doesn't concern. This is us, and this is court stuff. Sure. So. Were you provided with Rami Rosen's deposition?
Yes, sir.
Okay. Did you read that?
Yes, sir.
Okay.
Right, that's an example of a deposition that I reviewed but did not print.
Right, that's a very recent deposition. I think we just took that deposition 2 or 3 weeks ago, so
yes,
would have been flying around electronically long before we had paper copies.
Right. Again, I could have printed it but did not. I just read it off my computer. So it's possible I did that with Tom Savoy. I don't remember.
Okay. Pull it up. Tom Savoy at his deposition was asked, let's see, about gang activity. Were you aware of any gang activity on the property?
I don't recall graffiti or reports of gangs loitering on the property in any of the depositions or police reports that I reviewed.
Right. That's another reason, I mean, to the extent that Tom Savoy testified about gang activity, it'd be important for you to have that when you make your determination. True?
Assuming that I did not review the deposition, again, I don't recall.
Okay.
It's possibly I reviewed it electronically, I just don't know, but typically I review the depositions that are provided to me.
Right. And of course, if it wasn't provided to you, you wouldn't be able to review it, right?
If it was not provided, that would be correct.
Okay. Tom Savoy was asking, how did you know these guys were in gangs? He said, well, gangs meaning that they work together. I would think most of the people in there, talking about Madison Square, had some kind of gang association. That's the kind of understanding I had. Were you aware of that before today?
I didn't know he was a gang expert. Is he a security guard? Yeah,
Yes.
I didn't know he was a gang expert. I don't know how he can render that kind of conclusion without being a gang expert.
What's a gang expert?
Gang expert is somebody who's
Yeah.
been in the field,
Yeah.
who has dialogued with gang members,
Right.
who has hung out with them,
Right.
who has patrolled with police,
Uh-huh.
who have attempted to interview or interdict gang members,
Right.
a person who is familiar with gang territories,
Right.
gang symbols and signs,
Right.
and I did not know that Tom Savoy was any of those
Right.
things.
Is it your testimony that you have to be a gang expert to identify gang members?
I would think so.
Okay. Tom Savoy was asked about some other violent crime that may not appear at other places in the file, and you mentioned earlier that there were some black guys in a gang, and he answered, yeah, from what I heard, it seemed reports of them being a gang and reports of them just being a bunch of like low-life people who are just hanging around, and but then the report I got that there is people in the hall and they're making too much noise, which every day I go there somebody's making too much noise, so I said I'm going to take care of that after I take care of checking in the parking lot, because I don't want to have another break-in on that side of the parking lot. You recall reading that?
I don't.
Okay.
Yeah,
Do you know what?
I'm sorry. Just I checked to the form of that question. It's not clear even what point in time he is talking about.
I'll just, for the we got about 5 minutes, so we'll just go a couple more minutes and let
Sure.
the court reporter, if you want to take 5 minutes or something. Let's see. So I go there, and the other security guard was also notified. He said he saw them, and they had either he told them to leave or they knew they were doing something wrong and left. Either way, that was a bad situation. That they were hanging all the way outside this man's house, the man's apartment. I don't know if they wanted to get in, but I didn't hear anybody telling me they're forcing in an apartment. It's just that they shouldn't be there at all, and it's at night, and nobody and everybody's aware of there being noise in the halls all night. If you put on, you hear music, and you have music, people in the apartments can hear that. Small radio, they can all hear it. If you don't take it, you don't turn it on. You don't recall reading any of that stuff, right?
Frankly, that's not real intelligible, and I'm not sure what he means.
Okay.
I don't understand what he's saying there.
Right, it's hard. I mean, as you suggested earlier, you like to have, say, the full article or the full deposition for, what do you call it, contextual?
Sure.
Okay.
Assuming I don't have it, I don't know if that's true.
Well, do you want to look through your stack again and let me know?
I told you before, sir, that it's possible that I reviewed it electronically and didn't print it.
Do you have your computer here, your notebook? Or?
No, sir.
Okay. As you sit here in your deposition, you don't have it in your stack, and you're not aware of having reviewed it. True?
I told you that I don't recall either way.
Okay. He testified, talking about Madison Square. If I would have known it's as bad as I see it right there, I think I would tell someone. That's the same way it was October 2008. And so I know it's that bad. It couldn't mean much specifically, but whether I was there and looking at it, That's what I'm trying to infer. Let's see. Mr. Savoy, Tom Savoy, not Robert Savoy, his older brother, things started going bad in those parking lots. Now he's talking about the parking lots where Nicholas Surovec was murdered. Things started going bad in those parking lots about 4 months before Nicholas Surovec was murdered. He said, I was talking, they were bad. Question, yes, sir. Things were bad in those parking lots, yes. So they were getting worse in the parking lots, yeah. Well, more or less saying worse is that you can't seriously stop them with the amount of people they're able to pay for. It's a one-person night or a two-person night. You recall reading that?
I don't recall either way, sir.
Okay. So you don't recall the last security guard that was on duty before Nicholas Surovec was murdered, testifying about how bad it was in the parking deck when Nicholas Surovec was murdered.
Let me just state an objection to that lengthy recitation. It's not clear where it's coming from, so the extent it assumes facts not in evidence.
You may answer.
Well, I don't. It seems to contradict the crime data that I reviewed. Within about 3 months prior to the shooting, auto burglaries in the parking garages virtually stopped. I believe there was one between mid-July and the homicide date. So if that's what he says, that doesn't match up with the crime data that I reviewed.
Would that change your opinion, possibly?
I analyze data. It's not in the crime data. What this gentleman is saying is not substantiated by the data. So.
Have you ever heard of unreported crimes?
Oh, certainly.
Unreported incidents?
Oh, certainly.
Things where there's crime, even violent crime, and it's never reported to the police?
It's less true of property crime. Can be more true of certain violent crimes, especially domestic incidents.
Right.
But property crime tends to be reported very well.
Right.
And those crimes dissipated dramatically in roughly the 2.5 months, 3 months preceding your shooting.
We need to take a break for the videographer.
Going off the record at 11:25. Use the bathroom.
Sure. It's, I'll show you where.
We're on the record at 11:34 a.m.
So we're going to go until around noon.
Sure, that's fine.
See what this is again Tom Savoy's deposition, which we admittedly you may not have seen yet. Tom Savoy, again the last security guard we know to be at Madison Square before Nicholas Surovec was murdered, testified. He was being asked about how people get in and out of this 200-400 deck where there was a lot of crime at Madison Square. The only place you know of people going in and out of is through the overhead gate. The witness, yeah, the worst thing you want to have is an open gate in the back of the building. Talking about the 200-400 parking deck. I guess you agree with that?
Let me just state an objection to the form of the question. Assumes facts not in evidence, particularly the prefatory remark about lots of crime on the property.
Okay.
Are you talking about the sanitation gate that the workers use to dump the trash?
Well, I don't remember them referring to it as a sanitation gate. It's an overhead gate that they did egress, ingress, used to go to and from the dumpsters back there around that 200-400 deck.
Right, my understanding is that gate was open during the day.
All right.
And then when the maintenance people went home for the night around 5 or 6 o'clock, it was locked every night.
All right. And it's your understanding that was not an issue or problem at Madison Square, true, that gate?
For whom?
For anyone.
Well, you've been talking about it a lot in the deposition, so I suppose that's it has been an issue because you've been talking about it a lot in the depositions. But as in terms of a security concern over the nighttime in the parking garage, I haven't seen any evidence that that gate was unsecured at night.
Right.
There's clear testimony from the maintenance folks that it was open during the day.
Right.
They were the only ones that had a key, and they locked it at night before they went home.
And then Tom Savoy goes on to testify, which you may not have seen this. That's a bad problem. He's talking about that same gate there at Madison Square. Again, him being the last security guard that was there before Nicholas Surovec was murdered. Right, the overhead gate's a bad problem. His testimony answer, yeah. Especially when you got to hope someone before you remember to do it, right, which takes work. And it's some people just are too busy to remember at the end that they got something to get done, and you're too busy to remember to ask them. He's talking about you don't remember seeing anything like that.
I'd have to reread the full context of that statement to really give a comment on it. I think it's irresponsible for me to just give an opinion based on what you're reading to me.
Okay.
I'd have to reread the whole thing very carefully.
All right. Well, so now your testimony is you think you've read Tom Savoy's deposition?
No, I didn't say that. I said that I need to read what you're describing in its full context in order to give a reliable opinion.
Okay. And by read what I'm talking about, you mean read Tom Savoy's deposition?
Yes, again, or if I have not seen it, obviously I would read it for the first time.
Okay. Tom Savoy also testified about problems there before Nicholas Surovec's murder. And there's a lot I could read here. Part of his testimony says you don't know how bad it is till you actually see it. What the police wrestling with the thieves, intruders, that was before Nicholas Surovec was murdered at Madison Square. Yeah. The one I'm thinking was prior to that. Yes, sir. Prior to his murder, yes. Do you remember reading about that?
I remember that the incident you're talking about. I think.
Which one is that?
April 08, where either there was a security guard on duty who reported witnessing an auto burglar, or a witness who called the police. Police came out, and the offender essentially attacked the police officer during the offense, which is a great example of a data point that I made earlier about defiance and the functional limits of crime prevention. Clearly an offender who's willing to take on a police officer. It's a pretty good example of an undeterrable offender.
Right. I mean, that's, you agree for any would-be criminal, it's pretty brazen to attack a police officer, true?
Absolutely.
Okay. And that would create a concern that criminal activity like that someone may be seriously injured or killed, true?
Listen, if a police officer, if the immediate presence of a policeman can't stop a criminal, that's essentially the highest standard of crime prevention that you can apply to a property.
Right.
So I'm not sure what to say about that, except that some criminals you just can't stop.
Right. But you're not saying that about the two murderers who killed Nicholas Surovec.
As I said earlier, I'm not offering an opinion either way on that issue.
Right. But this is something, as you sit here, you don't recall reading this deposition transcript.
I don't recall.
Okay.
I know I've reviewed the incident report that he's describing.
Right.
Both from the witness who called the police, it was Mr. Blevins.
Right.
And then the officer who responded, who was attacked.
Right.
I don't recall Mr. Savoy talking about it.
Okay. Is that information ideally you'd like to have, the person that witnessed what happened as it was happening?
You know, I have the police report and I have the witness statement. That's sufficient for me.
Right. Tom Savoy was also asked about reporting on the issues with overhead gate. His testimony reads as follows: more or less, that was a pain in the ass to write reports because it happened so many times. So I'm trying to write a report every time it did happen. Question: it was a pain in the ass to write the report? No, a pain that it kept happening, and it would be stuck on up. And this is the next 3 days. You're playing with someone who doesn't have anything stopping people from going in the parking lot, and then you're writing it down, asking for it to be repaired, and you look at it, it looked so bad, badly damaged, you wonder what was going on with these people. And then you write a report that it's badly damaged, and you know management is, whoever's doing that is definitely whoever's causing that to happen. It's something out of control. I don't know what caused that, but writing a report of what you saw is most aggravating to see that always a problem. Do you recall reading that?
I don't recall either way. I do recall that being in direct contradiction to every other deponent who's ever testified about that gate. Florent Turnell,
Right.
Brendan Bolin,
Right.
Robert Savoy, LaDrew Jackson, Claudio Ham Ramirez. Virtually every deponent has said, yeah, the gate was open during the day for sanitation access for the maintenance folks. At night they locked it, and there was not a problem.
Right.
So that's in contradiction to every other deponent.
Claudio Ham Ramirez was a maintenance person, true?
I think he was a grounds person. So a grounds person.
Yeah. Do you recall what apartment he lived in?
I don't.
Okay. Do you recall who one of his roommates was?
I don't.
Does the name Chino Molino ring a bell?
Vaguely.
Do you recall him being a violent Hispanic gang member who's now imprisoned, who was living with Claudio Ham?
Object to the form.
Vaguely.
Okay. Do you recall an incident report where a car was crashed into the McDonald's immediately behind, and the people escaped to an apartment right there in the 200 building, which is part of the 200-400 parking deck, or adjacent to the 200-400 parking deck where Nicholas was murdered?
Yes.
Do you recall that apartment number?
I don't. Sorry.
Would it surprise you to learn that that was Claudio Ham Ramirez apartment number?
Would it surprise me? I suppose.
Okay. Why is that?
I don't know. It's just not every day you hear somebody crashing into McDonald's and then running into an apartment next door.
Right. Well, actually, the way the report read, I don't know if you recall the report, but it said escaping into that apartment.
Yeah, if you crash a car and you run, you're trying to get away.
Right.
So, yeah, I mean, that's an interesting offense.
Right. Interesting that they escaped into an apartment in the 200 building of Madison Square, too, true?
Just that they would do that in the first place. I mean, usually
Right.
if you ram your car into McDonald's, you don't run. I mean, you sit and wait for the police.
Right.
I mean, that's what you do.
Right. But it's not significant to you that they escaped into a Madison Square apartment there in the 200 building adjacent to the 200-400 parking deck where Nicholas was murdered?
I have seen no evidence that that car crash was in any way related to this murder or robbery. So I suppose the answer would be no. I don't see the connection between essentially them crashing into a McDonald's and then the murder. I don't.
Right.
And I'd like to know when the crash was, if you could refresh me.
Well, but as far as the connection, I mean, if you've got a history of crime on a property, you could have, for instance, you handle a case where there were 20 prior crimes in the year before, the incident, right?
What kind of crimes? I mean, not all crimes are equal, and crimes is a hugely broad concept, and it's quite frankly imprecise to really talk about crime in the general sense that you're talking about it.
Right.
In criminology, we're much more precise about distinguishing crime types from one another.
Right.
And then assessing their predictability of other crime types.
Right. But you wouldn't, I mean, if there were, for instance, 20 crimes that occurred on the property in the year or so leading up to Nicholas Surovec's murder, you wouldn't expect all 20 of those crimes to be connected to his murder, true?
What kind of crimes?
Any kind of
Like
crimes.
not paying your rent, speeding through the parking garage.
I'm sorry, not paying
Theft.
a rent's a crime?
Oh, you can get evicted for it. It's theft of service.
Not paying your rent?
Absolutely.
Okay. Where's... You don't have a legal background, right?
I'm a criminologist. We
Okay.
study law all the time.
So
you
where...
don't pay your rent, you get evicted. That's a crime.
Okay. So, and what is the crime for not paying your rent called?
I would imagine theft of service. It would probably depend on the jurisdiction.
Okay.
Because you're obviously living in a place, you're paying a service for which you're not, or you're supposed to pay a service
Right.
that you're not paying, and you're
Right.
getting a benefit from it. So that's theft of service.
Okay.
It would depend on the jurisdiction, I would imagine.
All right. That's your understanding about Texas and Georgia, or you don't know about Georgia?
I'm just talking very generally in a criminological sense about what
Right.
that would be.
So that not paying your rent, that being theft of services, would not be one of the crimes that occurred on the property that you would take into account when you put together your, I think, what you call analytics to make a determination about foreseeability of the crime we're talking about, Nicholas's murder.
If I do a crime pattern analysis for robbery homicide, I typically wouldn't look at evictions. I mean, unless there's some connection that I'm not seeing
Right.
between an eviction and a homicide. But that's typically not something that you would look at closely.
Right. Did you do a crime pattern analysis in this case?
Absolutely.
May I see it?
Sure. Here are my notes on the police reports. This would be probably...
Okay. And for the record, you're looking at Exhibits 4, which is a folder with your notes in it, right?
Right.
And we're going to call this 4.1, which is the document you pulled out of here.
So those notes essentially reveal to me that you have no predatory acts of violence against a resident in essentially the 3-year period preceding the incident, that you had no weapon involved or gun crimes in the garage in the 3 years prior. You had no injury involved, violent crimes against a resident in the 3 years prior.
Okay.
You had no escalation of an auto burglary or motor vehicle theft to a violent crime against a resident in that 3-year period.
Right.
Obviously the one policeman was assaulted, but that's the very definition of an undeterrable offender. Clearly there's no evidence that your incident escalated.
And by your incident, you mean Nicholas' murder?
Correct.
Right.
Started as an auto burglary and escalated to a murder. These are two guys with guns who sneak up on your client and rob them.
My client's late husband.
Right. It's tragic.
Right.
There was no evidence that there was any auto burglaries or motor vehicle thefts that night in the garage. So it's clear this is clearly not an instance of escalation.
Okay.
As far as I recall, there were no instances of escalation of property crimes into a violent crime against a resident in the 3 years prior to this incident. And so when you talk about a crime pattern analysis, that's the kind of thing that I did. I was looking at weapon involvement, crime type, place of occurrence, escalation or not. These are standard criminological variables we apply in a crime pattern analysis.
Right.
And so I didn't see it.
Okay. So you went back 3 years from Nicholas's murder?
That's a fairly standard reference period, 2 to 3 years. I typically go out 2 to 3 years, and that's pretty standard.
All right. And you mentioned these people, it was late, they were sneaking up on Nicholas and Krista, right?
Well, apparently, I mean, they came, they parked, they came from behind, they orchestrated this crime in such a way that, I mean, even if a guard was patrolling the garage, I don't know how they would even see this offense as it unfolded if it's unfolding in the car.
Mm-hmm.
They were sly enough to get the jump on the victims,
right.
and to not only get the jump, but to get in their car,
right.
Before they made any demand, which is unusual for, I don't want to say unusual, but it shows some calculation on the part of the offenders.
Okay.
It perhaps shows that they were preparing for this offense. Obviously they were, with 2 guns and 2 hoodies. Perhaps they were preparing to victimize these particular individuals. I will not be offering that opinion at trial.
Mm-hmm.
I don't know if this is a targeted crime. There's no evidence of it.
Right.
But it's consistent with that sort of offense.
What sort of effect?
Again, I won't be offering an opinion that this was a targeted crime, but it's certainly consistent with that kind of offense.
Okay.
But like I said,
well, we'll get to that. And in your view, whether there was a porous perimeter or whether there was a security guard or even 2 on the premises at the time of Nicholas Surovec's murder would not have made any difference.
Again, that's an ultimate issue opinion that I'm not going to offer. What I will say is that the porosity or lack of porosity of the property.
And that's porousness, porosity?
Porosity,
Okay.
Porosity. When you don't know whether the offenders have an internal connection to the property,
mm-hmm.
they live there, they're a guest,
right.
they're a friend of a guest, porosity is, to me, no longer relevant to causation.
Mm-hmm.
And obviously we don't know who these offenders are, so you can't exclude an internal connection to the property. And then secondly, if you assume, as your expert did, that there's a security guard patrolling dedicated to just the garages at the time of the incident, I find it hard to believe that, essentially unless the guard is standing very close to the vehicle,
mm-hmm.
that he could have had a meaningful deterrent effect.
Mm-hmm.
If he's in the garage next door, it doesn't seem to me like there would be any deterrent effect. And that's assuming that the posture was in place that your expert says should have been in place.
Mm-hmm.
And I believe your expert also testified that there would have been between 3 and 15 minutes where an offender or a hypothetical guard, wouldn't have been patrolling the 200, 400 garage. And given the way this offense went down and the timing of the offense, clearly there's opportunity to commit this crime without a guard being immediately present. Mm-hmm. Assuming that the simple observe and report security guard is going to have any deterrent effect on 2 thugs with weapons who shoot a person during a robbery, which is, again, a separate issue mm-hmm. that I'll talk about with criminological data. Whoops, sorry. I think that's enough for now.
So your view is that porosity of the perimeter would not have made a difference, true?
What my opinion is I can't say one way or the other because we don't know whether the offenders had an internal connection to the property.
Okay. And your testimony, your view is also that a security presence, even in the garages, would not have made a difference. True?
Again, I think that's not what I said.
Okay.
In my previous answer, I was very careful about contextualizing what I said, so I don't want to repeat it here. And part of your question again is an ultimate issue question for the jury to decide.
Well, but I'm entitled to your opinion, and so, well, then maybe your opinion is a security guard in the parking garages at Madison Square would have made a difference.
I'm not offering an opinion on deterrability one way or the other. I'm offering an opinion on the 3 sub-areas that I mentioned probably an hour and a half ago, which are the crime prevention posture at the property was adequate and reasonable relative to the risk of this incident occurring, that the best available criminological data and research indicates that burglaries are not a predictor of robbery homicide.
Okay.
And then thirdly, that obviously there are functional limits to crime prevention, and I will attempt to educate the jury with specialized criminological databases and research to illustrate those limits and the reasons for those limits.
Okay.
Notably, defiance, both evasive and confrontational. Well, those are the reasons for the limits.
All right. Well, then I want to talk about as far as contextualizing. Your first area was crime prevention and whether it was reasonable. My question to you was whether, in your view, more likely than not, security guards in those parking garages when Nicholas Surovec's was murdered would have made a difference.
I said before, that's an ultimate issue opinion that I will not be offering.
Okay, you have no idea whether it would have made a difference.
It depends on how close the security guard is to the offenders, if they see the security guard. Depends on the security guard's actions. I mean, there's a whole host of variables that are potentially in play that I can't address. So I'm not offering that opinion.
Right. Well, these questions I'm entitled to an answer. But my question, and we can read some back, but I'll. My question now is this: in your view, it was all right for the property owners not to employ any security guard when Nicholas Surovec was murdered. True?
It was adequate. The posture in place on the night in question was adequate and reasonable relative to the risk.
Okay.
So the fact that they didn't have a guard in that garage at the exact time that your client or your client's husband was killed, based on all the analysis I've done in this case, that was acceptable from a crime prevention standpoint.
Okay.
To not have a guard in the garage at the exact moment that the offense unfolded. Yes.
All right. And my question is not, and by night in question, I'm talking about when Nicholas Surovec was murdered. All right?
Yes.
My question is not whether it was all right for them not to have a guard at the specific, or I think you said exact location at the time Nicholas Surovec was murdered. My question is whether, in your view, it was all right for them not to have any security guards anywhere, which you know to be the case when Nicholas Surovec was murdered.
Well, correct. There was no security guard on property at the time of the incident. Based on all the records and evidence that I've reviewed, that was okay.
Okay.
And I'll explain why, in my opinion.
And it was okay because why?
Well, because it was part of an overall crime prevention posture that retained security patrols on occasion during the week. Obviously didn't have them there that night, but was part of an overall posture that showed reasonable care. And in criminology, we, perhaps in the legal profession, we don't demand perfection, we demand reasonableness. And the array of measures in place at this property at or near the time of the incident were reasonable from a criminological standpoint.
Right. So in your view, it was reasonable for the property owners to have 0 security guards when Nicholas Surovec was murdered?
What I will say is that it was not unreasonable to not have a guard patrolling the garage at the time of the incident. That's what I'll say.
Well, that's a different question. I'd like for you to answer my question. Would you read my question back, please, Madam Court Reporter?
So it was reasonable for the property owners to have 0 security guards when Nicholas Surovec was murdered, true?
Again, I will go with my previous answer. I think it's a better contextualized answer. A yes or no answer to that question is will be decontextualized and made to look in a way that I don't intend. What I'm saying is, based on the crime pattern at the property, based on the crime pattern in the garage, based on the nature of this offense, and based on the measures they had in place overall at this property, it was acceptable not to have a guard patrolling in this garage on this night at the time of the incident. That's what I'll say.
All right, and thank you. You've answered that question. My question's a little different. Would you read back my question, please, Madam Court Reporter?
So it was reasonable for the property owners to have 0 security guards when Nicholas Surovec was murdered, true?
Objection has been asked and answered numerous times now. He's given you his answer.
Yeah, I'm going to
Give me
stick
answer.
with my previous answer
but-
because a yes or no answer, sir, is not as truthful as it needs to be. And she swore me to tell the truth. And so a yes or no answer is misleading, I think, in a lot of ways. It's decontextualized from the larger pattern. It's decontextualized from the other measures that were in place at the property on the night in question. And it's decontextualized from the overall effort that was in place at the property. So I'm going to stick with my previous answer.
But you haven't answered that question.
I think I have, sir.
You qualified it to that garage each and every time. I'm entitled, if you don't answer the question, we're going to move to disqualify you, okay? Would you read back my question, please, Madam Court Reporter, and I'd like an answer to my question, please.
Well, he's already answered you've asked him it several times. He's given you his best answer he can give you. That's all he's required to do.
Do you read it back, please, ma'am?
So it was reasonable for the property owners to have 0 security guards when Nick Surovec was murdered, true?
And let me state an objection. Again, it's been asked, it's been answered. If I recall, we had a discussion in Mr. Gross's deposition where
If you have
you
an
stated...
objection, make an objection.
I am stating my objection, where you very clearly said he's answered the question. He's not required to give a yes/no answer. He's entitled to give his explanation. And he has given you his answer now numerous times. So object.
Would you read back my question, please, Madam Court Reporter?
So it was reasonable for the property owners to have 0 security guards when Nick Surovec was murdered, correct?
Same objection.
I'm going to stick with the previous answer I've given 3 times now, sir.
But you haven't answered that question.
Yes, I have, sir.
You've only answered it by saying that it was reasonable for the property owners not to have a security guard in the garage. That's not my question. Do you understand the difference in the questions?
Sir, I've answered the question 3 times now.
No, you haven't.
If you want to call Judge Purdom, we can talk to him.
Well, that's, I usually consider that amateur hour, but...
Well, that's fine.
Well,
I've
I'll
answered the
call
question.
Katie. Sadly, Judge Purdom had a heart attack, and I don't think he's due back yet, but I will see. What's that? Yeah, that'd be good. Thank you. Hi Katie, this is Jim Potts. I am calling regarding the Surovec matter. I am in Dallas, Texas, deposing the defendant's expert, and we've got an issue with the answer to a question. I'm not sure if Judge Purdham's even back yet, but if you would call me on my mobile at 404-307-4400, or have someone in the Atlanta office get me. Thank you. Bye. Okay. So you're refusing to answer that question again?
Objection. He's
No,
not
sir.
refusing anything. He's answered the question.
I've answered it 3 times, sir, and I've given you a fully contextualized answer. I cannot answer that question yes or no. I've answered the question.
All right. Answer that question again.
So,
Yeah. Okay. So it was good. So it was not reasonable for the property owners to have 0 security guards when Nicholas Surovec was murdered. True?
I don't believe that's what I said. Again, I've answered the question 3 or 4 times now.
And you're refusing to answer that question?
Objection. That
You may answer.
he's answered the question.
I've answered the question, sir. I don't know what you want me to say.
You haven't answered that question, Mr. Jacobs.
Yes, I have, sir.
No, you have.
Jim, he's answered the question. Let's move on.
No. I mean, are you refusing to answer that question also?
I've answered the question, sir.
No, you
3
haven't.
times.
Okay, let me state something. I'm reading from Jeff Gross's deposition, May 14, 2014. Mr. Dykeman, my co-counsel, asked a question and asked for a yes or no, and this is on page 22, line 2. Mr. Potts, objection. He is not required to answer any question yes or no, period. He can answer a question as he sees fit, period. I'm just, you didn't say the word period, I'm just ending the sentence. Also, he has ample opportunity to explain any question as he sees fit, period. Then Mr. Dykeman says, that I agree with. That was your objection, and that's the same objection here, and he's answered the question. Let's move on.
Okay. Yeah, that's what Mr. Neary read has nothing to do with my question and your answer. My issue with your answer, Mr. Jacobs, is that you haven't answered the question. What you've answered, and you called it contextualizing, but what you're doing or adding that it would not be unreasonable for the property owners not to have a security guard at, and I'll quote you, at the exact location, close quote, where Nicholas Surovec was murdered. My question has nothing to do with exact location. Does that make, or do you understand? Okay, so, but my question's not about exact location. The property owners didn't have a security guard anywhere on the property at that location or any other location. That's what my question is.
I understand, sir, but as you're well aware, this incident happened in the parking garage. Okay? So what's happening in the hallways of the apartment complex at the time of the shooting, I'm not sure I see the correlation between the hallway of building 100 and the parking garage of the 3rd level of parking garage 200, 400. My concern is, or my opinion focuses on the adequacy and reasonableness of the crime prevention posture.
Which would include security guards.
Particularly in the parking garage. In fact, in the parking garage, that's where the incident happened, at the time of the incident. So I've answered the question. I've given a fully contextualized answer.
But you haven't answered the question about whether it was reasonable for the property owners not to have any security guard anywhere on the property when Nicholas Surovec was murdered. Answer that question.
Objection, he's given you the answer.
I'm really focusing on the incident in question, where it happened, how it happened, and the other measures that were taken by the property, not just security guard, but all the array of measures that were taken by the property for a crime prevention effect.
But you've testified only that it was reasonable for them not to have a security guard at, quote, the exact location, close quote, of Nicholas Surovec's murder.
Correct.
That's not my question. My question is whether it was all right for them not to have any security guard anywhere on the property when Nicholas Surovec was murdered. I'd like an answer to that question. I'm entitled to it.
I've answered the question 3 or 4 times.
What's your answer to that question?
Well, it's on the record. He's stated, like you said, at least 3 or 4 times.
I
can have the court reporter read back my answer 3 or 4 times if that's what you'd like, because I'm not going to say it again. I've said it 3 or 4 times.
Yeah, and in each of those times you said at the exact location where Nicholas Surovec was murdered.
That's what's relevant to the incident.
That's not my question, sir.
That's what my opinion relates to. The incident in question, which happened in the parking
Right, but I'm
garage.
entitled to an answer to my question. You've admittedly not answered my question. My question is whether it was reasonable for the property owners not to have any security guard anywhere on the property when Nicholas Surovec was murdered.
I've answered the question, sir.
You're refusing to answer the question again.
Objection.
I've answered the question multiple times in a fully contextualized way. And the record will show that I've answered the question in a fully contextualized way.
So you're refusing to answer the question again.
Objection. It's not what he said, and that's not what he's
Well,
done.
then answer the question.
I have done so, sir.
You have not.
Yes, I have.
Jim, he's answered the question.
No, he hasn't. Are you refusing to answer that question?
He has not refused to answer the
Then
question.
answer it. He's either refusing to answer it or he's going to answer it.
He's given you his best answer to your question.
He hasn't answered that
Mr. Gross
question.
gave his best answers to our questions.
That there was no question about exact location where Nicholas Surovec was murdered. I'll take that as a refusal to answer it. We'll keep going. You were talking about your crime pattern analysis. You said you went back 3 years because that's customary, true?
Yes.
And you considered
2 to 3 years is typical.
Well,
I
you
went
went-
back 3.
All right. And you didn't see any incidents that regarding bullets, is that right?
There was an allegation, well, in the parking garage, absolutely.
Anywhere on
not.
the property?
There was an allegation of a bullet hole through a window that was essentially an unvalidated call for service. It was not corroborated by the responding police officer. There was no bullet recovered. There was no evidence of a bullet. The hole in question was described as a bullet hole by the callers. But if there's no bullet and there's no evidence of a bullet, I'm not so sure how you call that a bullet hole when there are equally relevant hypotheses for how this hole got in the window. In my experience, when somebody makes a call like that, it's typically, again, I'm not going to apply this to this case, but my experience is typically because of something that the individual has done, damaged the window, they need a police report to substantiate and not have to pay for the damage.
So in your view, that report was about someone trying to get out of paying to replace
I
the
said
window?
typically that's what I've seen, and I told you very carefully that I'm not going to apply that in this case. But typically that's what I've seen when there's a call like this and it's unsubstantiated. In other words, you say somebody shot my window and you look for the bullet and you look for any evidence of a bullet and the police come out there and look for it and they don't find it. It's pretty obvious that there's some alternative explanation than a bullet.
You agree that foreseeability requires that the general danger be foreseeable as opposed to the exact sequence of events that produce the harm, true?
Again, you asked me that earlier in the deposition. This is a sentence lifted from one of my publications where I describe how courts around the country have assessed foreseeability.
Well, but you assessed it in this case, right?
I assessed the likelihood of a robbery homicide on the basis of a burglary pattern at a property. That's what I assess. If you want to call that foreseeability, fine, but that's a separate criminological assessment.
Well, but in order, you don't take into account foreseeability when you reach your conclusions, the reasonableness of crime prevention, the best practices, and the functional limitations.
Oh, well, obviously you're sensitive to it, but foreseeability is a legal construct. Probability is a criminological construct that I assess scientifically with data, and that's what I did here.
So, in your view, it was improbable, based on what you found here, that Nicholas Surovec would be murdered.
Based on a pattern of auto burglaries and burglaries at a property?
Based on everything here,
Absolutely.
the totality of the circumstances.
Absolutely.
Okay. Do you recall reviewing an incident report regarding Kristen Chetzel, dated October 2004?
If it's more than 3 years out, I typically don't give much weight to it.
Okay, so you weren't provided with that?
I believe I recall. If you could provide me the incident report, I could refresh my recollection.
Okay. Here, let me see. Do you have the incident reports that you were provided?
I do, but I only printed some. The others are on the disc.
Okay.
And again, if it's more than 3 years out, I probably would not have printed it.
Let's go ahead and mark this. This is another stack of documents which you have reviewed, right? Which
Yes, sir.
we'll call this Exhibit 9 to your deposition. The lower right corner is Exhibit 9. The upper right says Plaintiff's Exhibit 111, right?
Yes.
This is a stack of documents you've reviewed, right?
Yes.
Just to be clear, those stack of documents he printed from documents that he reviewed.
Okay. I don't see it in here. I assume that either you saw it and didn't print it or you haven't seen it. What I'm going to do, we've got a notebook here with a number of incident reports in it. I'd like to keep this, Madam Court Reporter, if you could make a copy. make this number 10. I'll show you what's tab 1 of Exhibit 10.
Thank you.
I have seen this.
Okay. And that's an incident where it was dated October 8th, 2004, and it was apartment 2219, also serviced by that 200-400 parking deck where Nicholas Surovec was murdered, right?
Right.
And apartment 2219, heavy knock at the door. They looked, people, they saw 2 men in masks. Before they could call 911, the door was knocked down and the 2 men entered.
Object. Oh, go ahead.
That's all right.
I want to state an objection once you finish your question.
That's fine. You didn't take this into consideration in your analysis, true?
Let me state an objection
Okay.
that you selectively read part of that report there.
When I realized it was the friends of the ex-boyfriend's victim, or the victim's ex-boyfriends, it's
Right.
a domestic internal connection to the victim. It's domestic. Plus it's 4 years out. So no, I don't consider that an assessment of a robbery homicide in a parking garage.
All right. And then July 2005, July 23rd, apartment 4319. This is also in the 400 building, also serviced by the 200-400 parking deck where Nicholas Surovec was murdered, right?
I don't know. Can you give me the incident detail?
Yep. Well, first of all, it's apartment 4319, right?
Yes.
Okay.
All right, it's a burglary of an apartment.
All right. So this was a burglary of an apartment on July 23rd, 2005, 11:30 at night. It reads, resident states that someone kicked in the front door, stole only CDs, but left the TVs. The car keys were stolen along with the car. You didn't take that into consideration either, true?
If it's outside the 3-year window, I typically don't.
Let's see. Okay. The next one, tab 3 to Exhibit 10. This is dated December 27th, 2004. Business center, computer stolen from the business center. You didn't take that into consideration.
Again, I recall it, but it's outside the 3-year window, so it's not something that's pertinent to a robbery homicide in the garage.
Right.
4 years later.
Right. But anything within the 3 years that was at or near the property, you would have taken into consideration.
Not true.
Okay.
3 years is the general reference period. Obviously, the greater the recency of the incident, the more potentially pertinent it may be, depending on its location. So, an incident that occurs 3 years before an incident generally doesn't have the same relevance or recency as an incident that took place a week before an incident.
All right.
So.
Donna, is now a good time? I mean, we went about 25 minutes over.
That's fine. If you want to keep going.
Okay, so you want to go for, well, I'm going to need to eat something. What do you want, 40?
You want to go off the record?
Yeah, that's fine.
We're off the record at 12:25.
We'll go through.
We're on the record
All set?
at 1:26 p.m.
You mind? Can I see?
Sure.
Okay. think we were looking at a notebook with incident reports in it, which we've labeled Exhibit 10 with tabs 1 to 50 and then 1 to 50. I think it goes up to 31 again, which I'm going to keep this. The court reporter is going to make a copy, or we'll send her a copy of this. But I think we were up to tab 4 in an incident report. Incident location 1850 Cotillion Drive, Dunwoody, Georgia. Date is 12/30/2005. The charges were larceny, articles from vehicle. The narrative, page 2, reads in part, I responded to 1850 Cotillion Drive, Atlanta, Georgia, reference to 2 black male subjects breaking into a green Chevy Blazer parked next to a black BMW near the entrance of the parking deck. Upon arrival, myself and Officer M.M. Morales went inside the parking deck, located the 2 above suspects trying to hide inside their black BMW, leaning back in the front seats. Okay, we're good. Oh, we got you there?
Yeah, I'm here.
All right, we just started. If you don't mind muting, we'll just keep going.
All right.
Thank you.
Thank you.
Yep. I think I was leaning back in the front seats. Vehicle was parked next to the green Blazer. Driver's side window broken out. Suspects fit the description that the witness gave. I was conducting my investigation. I asked the driver, Andre Howard, if he lived at the location, and he stated nope. Then I asked him what he was doing in the parking lot, and he stated, quote, breaking into cars, close quote. Then I asked him, how many cars did you break into? And he stated, quote, about 9 cars, close quote. I guess my first question is, have you seen this report before?
Yes.
Right. And did you take that into consideration?
Yes.
Okay. Tell me about that.
Well, number 1 is it's an auto burglary. It's not violent.
Right.
Number 2, 2 security guards were on patrol the night this happened.
Right.
So it's clearly an example of crime in the presence of security, which I will use.
Mm-hmm.
3rd, it was not a violent crime. 4th, there was no escalation from the auto burglary to any act of assault in any regard.
Mm-hmm.
And, you know, again, it's exemplary of the kind of offenses that occurred in the garage over that 3-year period.
Did these break-ins, is it your understanding they occurred in the 200-400 parking garage, the same place Nicholas Surovec was murdered?
I didn't distinguish between the 2 garages. If it happened in a garage, it just noted it was in the garage.
Okay. So it makes no difference to you whether it was a garage where Nicholas was murdered or the other garage?
Not particularly.
All right. And this is the part, we're going through these, this is part of your crime prevention posture. You would take these prior criminal incidents into account, is that right?
Yes.
All right. So the next one, also 1850 Cotillion Drive, apartment 2419. Dated 1/9/2006. Do you have that?
Yes.
And that was simple assault, simple battery. True.
Domestic violence, yes.
Criminal trespass, yes.
Right.
And did you take that into consideration when you arrived at your conclusions?
Sure, yes.
All right. And why is that?
It's domestic violence. It's not a predicate to a predatory robbery homicide.
All right.
Didn't occur in the garage. It was almost 3 years out. That's about it.
All right. So it didn't. None of the prior criminal acts there on the property, and by the property I mean 1850 Cotillion Drive, would cause you to believe that Nicholas Surovec's murder was foreseeable. True.
Not auto burglaries and domestic violence, no.
All right.
Mm-mm.
The next is a dated 2/26/2006. True.
Yep.
And that is 1850 Cotillia Drive, 1103 Atlanta, Georgia, 30338. And did you take this prior criminal incident into account?
I looked at all crimes within the 3-year window,
All right.
and then I did my analysis.
All right. And your analysis regarding this prior crime on the property?
Again, it's another auto burglary or a series of auto burglaries.
Right.
Looked like there's several in one night.
Right.
Pretty common at an apartment complex. You have typically a spree offender who hit a property, hit it hard, and then move on.
Right.
When you see auto burglaries at a property, they're typically in bunches. Not always, but often.
Right. Would that create any concern for you that someone might come upon someone damaging or stealing a car, and there might be some sort of serious injury or
I've done
murder?
I've done analysis on that potential. It's extremely rare. For example, this research study that I had commissioned shows that.
Okay, let's go ahead and mark that as 4.2.
This study shows, and this is based on NIBRD's data, which is National Incident-Based Reporting System data, which is collected by the FBI. Essentially, nationally, for a 3-year period, 08 to 10, 1/100th of 1% of all burglaries reported to this database escalated to a homicide.
Mm-hmm.
And that's consistent with really good and available data in criminology about the rarity with which a property crime like burglary escalates to a serious violent crime. If the question is it more likely than not that a property crime will escalate to a violent crime of any kind, the answer unequivocally is no. It is not more likely than not that these property crimes will escalate, and the data are very convincing in showing that. There are a couple occasions on your property, or on the defendant's property, where I've separated these in my file,
Right.
where an offender and a victim did cross paths during a property crime, and consistent with all the available research, the offender runs. The offender flees. I think there were 2 or 3 situations where that happened, and this is typically what happens. If the offender is confronted by a victim during a property crime, they almost always run. Moreover, offenders go out of their way during property crimes to make sure the victim's not around when they offend. That's why the property crimes. So, for example, 6908 DeKalb Incident Report 08-076740, where a victim comes upon a burglar, the guy runs.
Mm-hmm.
Jumps through the window. 22706.
Which incident report are you? For the record, you're talking about.
What's up there?
Yeah, report date and time 6/9/2008, 1:20 p.m. This is 1850 Cotillion Drive. Incident case number 08-076740. This is Juliet Norfancy. Right?
Correct.
And this is, let's see, what, about 3 months before Nicholas Surovec's murder?
Correct.
And this is someone who walked in on an unknown suspect in her apartment. The victim stated as she had opened the door to her apartment, the suspect retreated to the bedroom window and jumped through the open
Correct. And that, again, that's the prototypical response that you see almost every time.
Right.
Where the offender flees as soon as he realizes the apartment is occupied or somebody is going to occupy the apartment and he's already inside.
Right.
Second incident, 22706, report number 06-028113. Auto burglary, the guy hears his window smash, he runs out there, the offenders run.
Right.
And then 6206 is an internal incident report. Apartment burglary. Victim realizes there's somebody in there. The offender realizes the victim's there. They run. And so it corroborates this exhibit 4.2.
Right.
And it corroborates everything we know in criminology about the lack of escalation of property crimes to violent crimes.
Right. Well, a burglary and a robbery are two different things, right?
Absolutely.
Right. So, a burglary, someone's trying to take something when no one's at home, is that right?
Yes.
As opposed to robbery when someone is actually confronting someone.
Yes.
Right. February 26, 2006, 3 o'clock. Also 1850 Cotillia Drive.
Which tab? Which tab is that?
This is tab 6. Did you take that into account?
Yes.
Okay. And you had to take all the, or at least within 3 years, all the criminal activity at or near 1850 Cotillion Drive.
I don't.
To make your, hold on, crime prevention posture determination.
Well, it's a crime pattern analysis, and that informs the crime prevention posture. So
All right.
it's related. But near, I think there was a couple incidents that were near. I really
Right.
looked on property.
Right.
And that's pretty typical to look on property.
Mm-hmm.
I think there was maybe one incident, the crash at McDonald's,
Right.
and then there was some kind of incident down the road a piece where somebody was, I think, carjacked, but that wasn't at the property.
Well, there were actually two, but depending on which one you're talking about, one, the MO or modus operandi was nearly identical to the Nicholas Surovec murder. True?
I'd have to see it.
Okay, we'll get to that. We'll go through these. Okay. Well, actually, we talked about this, right? You took it into account. It did not make it more likely that someone like Nicholas Surovec would be seriously injured or killed because it's a burglary, a property crime, and it didn't.
You're talking about the 22606?
Yes.
Yes.
Okay.
The 22606 auto burglary. Yes.
All right. And then this is tab 7, exhibit 10, 22606. We've got yet another victim of a you call this an auto burglary.
Yes.
And you also took this into account.
Yes.
And it also, and when you took it into account, how did it factor into your analysis?
Again, it's an annoyance. I've gotten my car broken into multiple times.
Mm-hmm.
It's a pain. You got to get stuff replaced and fixed, but it's not dangerous to the victim.
Okay.
It's an annoyance. I agree.
All right. So it didn't have any impact on your analysis?
Only insofar as I considered it to exclude the relationship between these auto burglaries and this robbery homicide.
And by relationship, you mean like the same people involved, or
Just
what?
as crime categories, I mean, again, auto burglaries are a different animal than robbery homicide. Your incident was not an auto burglary that escalated. There were no auto burglaries reported on the night in question. There were no prior auto burglaries that escalated to violence against residents or guests.
Right.
So I considered it, but then I consider it against that backdrop.
So it's really not part of your determination?
Well, I think I just answered. I mean, again, I considered it, but against the backdrop of, it's not like I'm ignoring that these happened.
Okay.
Okay? But I'm distinguishing these offenses from your offense and why they're not predicates.
Okay. You didn't ignore it, but it was not a predicate. In other words, it it didn't indicate to you that Madison Square or the property owners needed more security.
Correct.
Okay. 2/26/2006. This is tab 8 and exhibit 10. This is more of the same, right?
Yep.
Same analysis, right?
Yep.
Tab 9.
And I'll just, if I could
Sure.
just add, I believe that night,
Which night?
2/26/06 to
Yes.
the 27th,
Yep.
there was a security guard on duty that night.
Right.
He got off at 5 o'clock in the morning.
Right.
And some of these, the time range in some of these offenses are after 5 a.m., so I don't know if he was there at the
Right.
time of the incident, but
Right.
he was scheduled to work the very night where you had all these burglaries.
Right. And you know that over the course of the several months leading up to Nicholas Surovec's murder, security was eliminated. True?
Object the form, since facts not in evidence.
The security guard hours were dramatically reduced
Right.
in the 3 months prior to your incident.
Right.
And I believe they were moving to a courtesy officer format. But, so, I wouldn't say eliminated, but the guard hours were definitely reduced.
Okay. And you think the reduction in guard hours by the property owners was appropriate in the months leading up to Nicholas Surovec's murder?
Based on the crime pattern analysis, with basically with one exception, no auto burglaries or motor vehicle thefts or crimes in that garage in roughly 3 months prior to the incident, that's reasonable. I mean, most criminologists, security practitioners will tell you that if you have a dramatic drop-off in criminal incidents in a particular place, that it's acceptable to ramp down a bit. And if it goes back up, then you ramp up. I mean, that's pretty standard practice.
All right. And you're an academic, is that right?
Partly. I mean, I do a lot of work in the real world.
All right.
But yeah, I'm partly academic, but I do a lot of applied work as well.
You teach at UT Dallas, you're in Dallas, right?
Among other things, yes.
But, have you ever overseen security at an apartment complex?
I've advised, overseen it, no,
Right.
but I've advised and counseled various entities about crime prevention, including apartment complexes.
Right. You've never worked as a security guard, true?
Correct.
Okay. You've never worked as a supervisor to a security guard, true?
Correct.
You've never overseen security at an apartment complex or parking?
Well, I'm the chair of my university's Safety and Security Council,
Right.
which includes apartment complexes at our campus. Essentially, as chair, our council is tasked with developing, implementing, and evaluating a comprehensive safety and security plan for a campus of 21,000 students and 20 million square feet of property. So I'm the chair.
Right.
And we have apartments on our campus, but I'm not the director of the apartments per se. But I certainly counsel and advise with regard to these issues with the council.
To ensure that there's a plan in place for the protection of the people at UT Dallas.
As far as reasonably possible, I mean, you can't protect everybody 100%, but you have a plan in place to try to deal with contingencies, and that's what we do.
All right.
But I have advised other apartment complex entities around the country in the past. So
There are a number of those in your CV where you talk about security analysis, I think you call it. And it looked to me like that security analysis was incident to cases you helped with, like you're helping the defendants in this case. Is that true?
both.
Okay.
Some were and some weren't.
Okay. I think you've testified in what, 292? Or you've been an expert in a premises liability case 292 times?
I don't know if I've used 292. It's probably close to 300.
Okay.
I don't think I've ever used I've estimated to be around 300.
Okay.
I don't know if it's 292.
All right. And of those 300 or so times, more or less, that you've been an expert in a premises liability case, in all 300 you would have done an analysis, right?
Typically. You mean of the property?
Well, of the situation, which would include the security on the property, if it involved security on the property.
I mean, I can think
Or
of a
lack of
couple
it.
exceptions, but generally speaking, that's what we do, yeah.
So and a couple of exceptions, you'd mean like 2, 5, 10, something like that.
Probably.
So between 290 and 300 of them, you would have performed that analysis commensurate with your work as an expert.
Oh, you mean
in
on
the
that
case.
list?
Yes.
Oh, no. The list includes a lot of properties that were maybe adjacent to the litigated property. And so
Right.
I did surveys or analyses of proximate properties
Right.
to see what the customs and practices were in the area.
Right.
So those businesses had nothing to do with the lawsuit. And then there's other businesses or properties that I've analyzed, or provided counsel for separate from litigation.
Did you do analysis for adjacent property in this case?
You know what? I don't think I did. I canvassed the area on my visit.
Right.
And I think I might have looked electronically for apartment complexes nearby, but I don't think, as I recall, there wasn't a big density of apartment complexes nearby.
Do you recall how many were quite close or?
I don't. I just don't recall there being a sufficient density to warrant a systematic survey.
All right. Did you review the DeKalb County homicide file regarding Nicholas Surovec's death?
Yes.
All right. Did you see the maps that the officers used with 1 and 5 mile radiuses depicting other apartment complexes?
I don't know if it focused on apartments. I know there was a 5-mile radius used, which was huge.
Right.
And I'm not sure it focused on apartment complexes, but I vaguely recall seeing some analysis of some kind in that file.
Well, I think, the analysis there was something a little different. They were looking for similar crimes in the area to try to see if they couldn't piece together evidence to, tie this crime to other crimes to try to catch, in this case, a killer, right?
Right, and I think they didn't go back very far in time prior to your murder, and I know they used a very wide radius.
Right. Just didn't know whether you'd seen there were other crimes, and within those maps that were in complexes quite near this one of which was nearly identical to this, where you had 2 suspects, the guns, back of the car, go to the apartment. You recall that?
I think I do, now that you say that, yes.
And that is something that you would want to take into account when making your determination in this case.
I don't recall when that incident was relative to yours. It may have been after. I think it was after yours. Was not?
We'll pull it up.
Okay.
But
and I don't know how close that incident was to your incident. But this is not something the apartment complex would have had any clue about, especially if it's an unsolved crime.
Mm-hmm.
They're not going to have access to that report. So it's not necessarily something that I consider.
do you recall Rami Rosen testifying that he was aware of criminal activity in the area, properties other than the 1850 Cotillion trial?
I have some notes on him.
This is part of Exhibit 4, right?
Right.
Let's go ahead and mark this. These are, we'll call this 4.3.
Mm-hmm.
Thank you.
So your question was, he recalled crime around the property?
Yeah, he testified that there was other criminal activity in the area, that he was aware of criminal activity, and that in part the reason things were so bad at Madison Square or the 1850 Cotillion Drive was because of the crime in the immediately adjacent area or nearby areas.
Let me object to the form of that question. I don't think it reflects the testimony correctly.
I don't think that's true, sir. What I have here is that you questioned him about crimes in the area, and he responded and didn't seem to know that they had happened. And maybe I'm misremembering.
Let's pull it up. I think it's just a second. If you look at page 191 of Rami Rosen's deposition.
This is one I didn't print. I just
Is
took
that part
notes.
one or
Oh,
part
that's
two?
okay. All right, I'll just read you. I mean, there are numerous places in the deposition where Rami Rosen testified about crime in the area. At 191, there's been a rash of car break-ins in the area and at our property. True, yes. We've been informed of several instances of criminal activity that has occurred in the area and at our property. That's at page 198, looks like. Let's see. All right, if you look at page 213, this is Mr. Rosen's testimony. First of all, safe is a relative term. So for Atlanta, in this kind of situation, at this point, I guess this was safe. We're trying to draw a picture here of a gun shooting, crime-infested area, which I have to say, I stayed at Dunwoody myself many times. Well, that's not the, let's see. Page 221. Let's see. Let's see, anyone that lives in that area knows Dunwoody, knows Atlanta, will tell you that, so that goes with the territory of the
What page you at?
location.
I'm sorry, what page?
220, looks like 220, let me make it, 221, I think.
What line?
221.
I mean, what line on page 2?
19 to 25. Let's see. Let's see. Whoop. Hold on. Find another. That's two parts of a deposition. I'm not sure. I don't see what I'm looking for. You didn't take into account property occurring at any property in that area of Madison Square, true?
Crime occurring in other properties?
Correct.
I focused on this property, right?
Okay. You also did not take into account what other properties in the area were doing as far as security.
Right, as I said earlier, I believe I looked around, but the density was sufficiently low that it wasn't a meaningful analysis.
Okay. All right, I think we're up to number 10, tab number 10. This is 1850 Cotillion Drive again. This is February 27th, 7 o'clock in the morning. You've reviewed this document as well.
22706?
Yes.
Yes.
And this is another what you call car burglary, is that right?
Right.
And in your view, did this impact your analysis? Did you take this into account?
Well, yeah, I took it into account, but it doesn't change my opinions.
Okay.
I mean, again, I've said it numerous times.
Right. So this is, we'll go ahead and, for each of these thus far, you took them into account. In other words, you did not ignore them, but they didn't impact your analysis.
Well, they impacted it in the sense that I don't use these as predicate crimes, and criminologists don't use these as predicate crimes for robbery homicides. They're not predicates.
All right. And as far as your analysis about crime prevention measures, taking these into account, you still feel like the property owners had adequate security, both the perimeter and adequate number of security guards at the time of Nicholas's murder?
Well, again, at the time, they weren't patrolling.
Correct.
But again, given the totality of the circumstances in terms of the dramatic reduction in burglaries in the 2 to 3 months prior, and all the other measures that they had in place, and the difficulty of preventing auto burglaries even with the guard on duty at the time, it was reasonable.
Right, and by other measures, I mean, there were no cameras in the parking deck where Nicholas Surovec was murdered, true?
Well, the other measures get to this page,
Okay.
these 2 pages.
Call this 4.4.
Right.
And these are what, your notes regarding measures that...
Just some notes from the depositions of the different things the property was doing to affect an adequate and reasonable crime prevention posture and relative to the risk of this robbery homicide occurring. And so these notes reflect that.
All right, that's it. So 4.4, your notes regarding adequate security, or what you considered adequate security. Surveillance cameras positioned on the property, true?
And these are in no particular order. Yes, the cameras on the garages, right?
Right, and the cameras on the garages focused only on the entrances of the garages, true?
Correct.
Those were not monitored, true?
Not monitored real time by a person?
Correct.
Correct.
And there were no other cameras on the property, true?
I think there may have been some in the leasing office, but maybe I'm misremembering.
Okay. Any other cameras on the property that you're aware of?
I don't think so.
All right. And any other cameras on the property, to your knowledge, at the time of Nicholas Surovec's murder, other than
Not that I recall.
Okay. Did you watch the surveillance video?
Yes.
Okay. And that was taken by the cameras on the opposite deck, the 100-300 deck. True?
Yes.
Window locks, how did that affect Nicholas Surovec's murder?
Again, this is part of the overall crime prevention posture, not knowing that a robbery homicide was going to occur in your parking garage on October, was it 4th, 2008? So what's the general array of measures that the property has in place to deal with crimes of different kinds?
Right.
And obviously, you know, window locks, peepholes, deadbolts, these are all standard measures that any apartment complex would put inside the units.
So you would take into account things like deadbolts, window locks, and peepholes, but not prior crime on the property if it wasn't a crime directed at a person. Is that right?
No, I address all crime, but I distinguish larcenies from robbery homicides, burglaries from robbery homicides.
Right.
For the reasons I've already talked about today.
Well, certainly they're different. At the same time, do you not see a potential security issue if you've got 9 cars broken into one night, 7 cars another night, 3 another night, you've got apartment doors kicked in, you've got burglaries, numerous burglaries. Doesn't that cause some concern about the overall security at the property?
You know, it's at virtually every apartment complex in America, you're going to find auto burglaries and unit burglaries. There's really nothing you can do to entirely eliminate them. Auto burglaries in particular are often driver-driven. In other words, there's certain things that vehicle drivers can do to either reduce the risk or eliminate altogether. And this is the principle behind the lock, take, and hide campaigns that every police department around the country publicizes to the citizenry. That, you know, lock your car. If you have valuables, take them with you. Don't leave them in plain sight. And if you have to leave them in your vehicle, hide them. So, auto burglaries, I'm not sure you're ever going to have a security posture in place that entirely eliminates auto burglaries, because the rapidity with which they occur. I mean, literally, let me back up. The rapidity with which they occur and the ease with which they can occur even with security on site, particularly at a large property where security can't be by every vehicle. You know, I've interviewed hundreds of offenders, analyzed thousands of crimes, and these things can be done in a matter of 10 seconds without anybody knowing until you're gone. And there's not a reasonable way to stop that kind of crime. I mean, absent, you know, an enormously heavy security presence where there's guards surveilling not every car, but where the ratio of guards to cars is very, very high, the site will be vulnerable potentially to auto burglaries. There's no way around it.
Right. Well, you said entirely eliminate. I don't believe I suggested or even intimated that, you know, I was talking about entirely eliminating car break-ins. You also mentioned locking a car, taking valuables out of a car, hiding valuables if you choose to leave them in a car. None of those things would have made a difference in Nicholas Surovec being murdered. Do you agree with that?
Correct.
Okay. All right. So window locks, deadbolt entry locks, those didn't have anything to do with Nicholas Surovec's murder.
It's part of the crime prevention posture at the property, and so that's the larger question. What are they implementing measures that are adequate and reasonable relative to the nature of the property and the risk at the property? And those are part of a reasonable crime prevention posture at an apartment complex.
Right. And just so we get my question clear, whether there are locks on the windows, whether there are deadbolt locks on the doors, whether there are peepholes on the doors, don't have anything to do with a murder in a parking deck. True?
With a murder in the parking deck, per se, correct.
All right. Now you've also got the parabolic mirrors and the mesh and cable fencing. The parabolic mirrors, those are the ones that they're curved so you can see around corners. Is that right?
Right, and they also give visibility to potential lurkers if you're in a parking garage.
Right.
And you use the mirrors to see what's around you, sure.
All right. In your view, it was also acceptable that the property owners didn't have any security cameras in the parking garage where Nicholas Surovec was murdered?
In the actual garage, it's fine. I mean, you know, cameras don't necessarily, in fact, there's a lot of evidence to suggest that cameras don't have much of a preventative effect on violent crime.
Mm-hmm.
For some situations, in some venues, they can have an effect on property crime. I wouldn't be against it, but in my opinion, it wouldn't have changed the outcome of this incident to have a camera. All the evidence suggests it would not have.
All right. Looking at tab 11 of Exhibit 10, again 22706. This is 3 o'clock. What's this, 3 o'clock to 8 o'clock? Again, entering an automobile. That's something you would have considered, not ignored, but it was not determinative in your analysis regarding Nicholas Surovec. This again is a property crime. Nicholas Surovec was killed by armed robbers, and in your view, there's no indicia associated with this incident report that someone might rob someone with a gun in that parking deck.
That's what all the criminological data shows,
Okay.
and all the research that I've talked about a couple times today.
All right, which again buttresses your notion that security was adequate at the property at the time of Nicholas Surovec's murder.
Relative to not having a guard in the parking garage at the time of the murder, yes.
All right, and well, and relevant to not having a guard on the property at all.
Well, I suppose. I mean, again, I'm focusing on the garage because that's where the incident happened.
Right.
You know,
Excuse me.
yeah. I mean, I'm focusing on the garage because that's where he would have had to been to have any potential deterrent effect on this robbery homicide.
The garage is part of the property, true?
Yes.
And if you have security on the property, they can have a deterrent effect throughout the property, as long as they're visible, which, of course, if they're there, they're supposed to be. True?
Maybe. I mean, it depends on whether the offender sees the guard, where the patrol is relative to the offender, if the offender even is in those parts of the property before offending.
Mm-hmm.
So, I mean, for me, I'm focusing on was there a guard in the parking garage? Was there a guard in the parking garage, and would that guard have been available as a deterrent in the garage?
Okay. And there was no security guard in the parking garage, true?
True.
And you don't know whether that security guard would have been a deterrent, true?
There's no evidence. You mean in the garage?
Yes.
That's an ultimate issue opinion that I'm not going to offer. That's the jury's call.
Okay, so you can't offer an opinion about whether a security guard in the garage at the time of Nicholas Surovec's murder would have had any deterring effect.
I'm not offering opinion in that realm.
Okay. This is tab number 12. This is an Altman Management Company incident report. It's dated June 2006. This reads, in pertinent part down at the bottom, resident witnessed 2 black males leaving his apartment. A chase ensued. Resident lost them in parking garage. Police continued chase. Missing items included camera and PlayStation. Joanna Oswald. Do you recall that?
This is the one I think I flagged earlier.
Yes.
June 2nd, 06.
Yes.
Apartment 3104.
Right.
Where this is a pretty typical reaction, where a victim stumbles upon an offender during a burglary. The
Right.
offenders run. It's
All right.
very, very typical. And that's exactly what happened here.
All right. So,
And
like,
if I could add,
Sure.
sorry, it's also very consistent. Most apartment burglaries happen during the day.
right.
This happened around 3 in the afternoon. So it's consistent with, and that's because they target these apartments when they believe the victim's at work. So they don't
Somebody's
want-
at home. The last thing they want to do is confront someone, right?
Correct.
And the problem being that if someone did walk in on a burglar, if the burglar was armed, I mean, the resident could absolutely get seriously injured or even killed. True?
It's more of the, I mean, all the studies indicate that burglar is rarely armed during a burglary. And the burglars I've talked to, they're more afraid of the owner coming upon them while they're inside than anything else. Especially in well, in Texas, where the castle doctrine, I'm not sure if Georgia has that, but they're scared to death of getting shot while they're inside the unit.
Has that reduced the amount of burglary in Texas?
I would think so. I haven't done a systematic analysis, but these offenders know that, and that's why they target the place when you're not there. You know, because they don't want a confrontation.
Right. So, again, this is tab 12, the June 2nd, 2006 incident report. You would have taken that into consideration. You did not ignore it, but it would not impact your view that the property owner's security was adequate at the time of Nicholas Surovec's murder. True?
Correct.
All right. Tab 13, also June 2nd, 2006. Resident came home and discovered her apartment had been completely ransacked and her laptop, camera, credit cards, checks, and underwear stolen. Entry was made through back door. You took that into consideration as well?
Yes.
You did not ignore it? True?
True.
Because this was a burglary, it did not impact your view that the property owner's security at the time of Nicholas Surovec murder was adequate. True?
Correct.
All right. Tab number 14, also June 2nd, 2006. Came home on, it looks like 6906, and discovered his door on his patio had been entered during his absence. No belongings missing. Have maintenance repaired door. This is something, go ahead.
I don't want to break that. What apartment number is it?
3106.
I have 3107, but
Well, it's both of them. It's
Okay.
31. I think we just did 3107.
okay.
But well, it's 3104, 3106, and 3107, all on June 2nd, 2006. All of these reports you would have considered. You did not ignore them at the same time because they were apartment burglaries. They do not impact your view that at the time of Nicholas Surovec's murder, security at 1850 Cotillion Drive was perfectly adequate. True?
Well, security is never perfect, but adequate.
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 And
It doesn't affect the burglary at this daytime burglary, roughly 2 1/3 years before your incident. Doesn't affect my analysis of this robbery homicide 2 1/3 years later in the garage.
well, it's part of your analysis, but it doesn't change your view that security was adequate at 1850 Cotillion Drive when Nicholas Surovec was
Yeah, I
murdered.
would call it the crime prevention posture, and all my opinions are focused on the crime prevention posture as opposed to quote unquote security.
All right.
Security implies that you can indeed secure a person's safety, which no apartment complex can do.
Right.
But you can take positive measures that inform an overall posture that inhibits offending, and that's what my opinion revolves around.
All right. So that we get that through Exhibit 15 and this, through tab 15 and Exhibit 10, all of these incident reports that we've covered so far, while you took those into account in your analysis to make your property
Posture.
property
The crime prevention posture.
crime prevention posture. In your view, the property owner's crime prevention posture when Nicholas Surovec was murdered was adequate. True?
Was adequate and reasonable relative to the risk of this particular incident occurring.
Right. And the risk was low because, well, up until tab number 16, the crimes on the property were, by and large, property crimes. True?
Yeah, you have essentially a 3-year history of essentially no predatory violent crime on your property and in the parking garage. I mean, And that's as clean as it gets in terms of predatory violence, 0.
All right. Well, let's, moving on to tab number 15 for Exhibit 10, 6206. Gun and laptop stolen from apartment 3204. Same answer, right?
Yes.
Tab number 16, also June 2nd, 2006. After being notified of other burglaries, maintenance staff found back door of this unit ajar. Resident was called and they came home missing some shirts and shoes only. Same answer, true?
Yes.
Tab number 17, also June 2nd, 2006. Apartment also broken into through back door, did not find anything missing as of yet. Your answer would be the same regarding this, true?
Yes.
Tab number 18, this is an aggravated assault, 10 Peachford Circle, Atlanta, Georgia. Do you recall reading this report?
Is it 62806?
It is June 2nd, 2006.
If you could give me some additional details.
Sure. You just show it to them? Sure.
I read this.
All right.
This was down the street or away from the property. Somebody
Actually,
jumped.
quite close. Are you familiar with the area?
Yes.
Okay.
So this is about almost 2.5 years earlier.
Right.
It's off property. It looks like she was getting her mail. Somebody jumped in the car, kids in the back.
Right.
And they took her car, and then she got her kids.
Right.
I guess her kids were dropped off somewhere. So yeah, I looked at this and I considered it, but again, it's off property. It's almost 2.5 years before. It's in broad daylight. It has nothing to do with the parking garage.
And it doesn't change your view that the crime prevention posture for 1850 Cotillion Drive was adequate when Nicholas Surovec was murdered, true?
Correct.
Tab number 19. This is July 6, 2006. Residents were at home, purse with wallet, cell phone, computer tower, screen. Apartment 4201, did you see that?
If you could show it to me.
Sure.
So this is an apartment burglary.
Right.
I didn't jot this one. Oh, wait a minute. Yes, I did. I don't have a note on this one, but I believe I recall seeing this one.
All right. And for this one, your answer would be the same. You would have taken it into consideration like all the other incident reports, but it does not impact your determination that the crime prevention posture at 1850 Cotillion Drive was adequate when Nicholas Surovec was murdered, true?
Correct.
That's, in this case, again, that's because it's a burglary, not another armed robbery.
Well, in addition, it's 2.25 years before. It's remote in time. It's not violent. There's no weapon. There's no confrontation. There's no assault. Doesn't occur in the parking garage. It would not be a predicate, in my opinion, criminologically speaking, for a robbery homicide in the parking garage.
Okay. Tab number 20. which is October 9th, 2006, Madison Square Club Room. Came in this morning, leather sofa stolen. You recall reviewing that?
Yes.
Same answer, took it into consideration. Doesn't impact your view that crime prevention posture was adequate when Nicholas Surovec was murdered. True?
Yes.
November 27th, 2006, 1850 Cotillion Drive, criminal trespassing. Do you have that?
If you could continue.
Sure. Incident case number 06165-982.
We lost him.
You can call by.
Yeah.
Responded to a reported open door at 1850 Cotillion Drive. On arrival, I spoke with Ronald Johnson, complainant. Johnson said that he was a security officer for the complex. During his rounds, he noticed 3 doors that were damaged. I found 1 door damaged at building number 300. The door and the lock were broken, and the lock was in the lock position. That room occupied the cable and telephone service for the building. Also found 2 doors damaged in the same way in building number 400. 1 door for the cable and telephone service and the other for storage. Is that right?
Yes.
You've reviewed that one as well?
Like I said, it's the same answer. I mean, these are
Okay.
all
right.
annoying property crimes.
Tab number 22. This is theft by taking, also at 1850 Cotillion Drive, November 30th, 2006. And theft by taking is a little different, right?
Well, it depends on the state and the jurisdiction if you
Okay.
continue.
This is 4 hubcaps from our 2005 Toyota Camry were taken while parked on the 3rd level of the parking garage.
I mean, again, I would call that an auto burglary.
Okay.
You're not actually entering the vehicle, which is why they call it theft by taking,
Okay.
but it's a larceny.
All right. Same answer for that.
Yes.
On to January 2nd, 2007, burglary, forced entry, residence. Responded to a burglary call. Miss Belfon got home, unlocked her front door, and entered her residence. Noticed her laptop, computer, digital camera gone. Right?
Yes.
While apartment 4113, also serviced by the 200-400 parking deck where Nicholas Surovec was murdered.
Yes.
Same answer.
Yes.
Tab number 24, entering an automobile, intent theft, 1850 Cotillion Drive, apartment 2213. 2213 also accessed by the 200-400 parking deck. True.
What date?
This is March 12th, 2007. You have that?
Yes.
Same answer for that one. True.
Yes.
Tab number 25 for the record. August 1st, 2007. Emily Simmons. This is an Altman incident report. Woke up, looked to the left, out bedroom window, and there was a man on my balcony banging on window. I screamed, and he went off the balcony.
As I recall this incident, it was either LaDrew Jackson or Florent Turnell who said that this was either the boyfriend of the victim or a guy who lived directly above her that was trying to get into his locked apartment.
Mm-hmm.
So yeah, I considered it, but once that testimony, and I believe it was LaDrew Jackson that spoke with the victim personally.
Do you know who LaDrew Jackson is?
He's, I think, one of the Crown supervisors.
Correct.
And that's what the that's what his testimony was. I believe that it was an ex-boyfriend.
All right. So that so your same answer.
Right.
Not indicative of any issues with crime prevention posture at the time of Nicholas Surovec's murder.
Correct.
Or even at this time, up through this tab 26 and exhibit 10, none of these have indicated an issue with the property's crime prevention posture. True?
Well, I really focused on October 4th, 08.
All right.
So I don't, I didn't focus on that particular question.
You don't have an opinion before October 4, 2008?
Not particularly. I mean,
Right.
I'm focusing on what they did
All right.
up to that point.
You recall reviewing a resident notification letter dated 19 February 2008?
Yes.
And same answer for that.
Oh, that's a great thing. They're giving notice. I encourage departments to do that, to make people aware. If there's a rash of break-ins, let people become aware so they can take measures to protect their valuables.
Right.
That's the best way to prevent an auto burglary, is just take your stuff, lock your car, and hide it if you can't take it.
Right. And in order to provide notice, you have to be on notice, true?
Yeah, I mean, they're obviously, their security guards are telling them that this is occurring, and
Right.
so they report it to their residents.
Right. June 9th, 2008, Juliet Norfancy, I believe you spoke about this briefly earlier. Home intrusion, resident came in and caught the person, then immediately called the police. The suspect left outside the patio door.
Right.
Same answer for that?
Right, I mean, this is, again, the classic response of a burglar who's surprised by a unit owner. They flee.
Right.
And it's corroborated by the NIBR study that I provided.
Right. So same answer doesn't impact your view.
Again, my opinion is that the posture, the crime prevention posture at this property was adequate and reasonable relative to the risk of this incident occurring, this robbery homicide. So, yes,
Right.
the crime pattern analysis feeds into that opinion.
All right. Tab number 28 of Exhibit 10, aggravated assault, battery, gun, robbery, street gun, kidnapping, adult. This is 1945 Savoy Drive, 2200, Atlanta, Georgia.
What date?
June 13th, 2008. You have that?
Yeah, I don't have it in my notes, but I remember reviewing this. If I could see the narrative.
Sure. For the record, this is tab 28, Exhibit 10.
Right. This is off property, and it looks like there's an internal connection between the victims and the offenders. Yeah, looks like it started at 235 Perimeter Center Parkway. And so the crime started substantially far away from where it ended, and then it ended at 1945 Savoy Drive, which is not your property. So I remember reading this, but looks like a targeted crime as well. Yeah, I'd like to know what the distance is from 235 Perimeter Center Parkway is to 1945 Savoy. Sounds like it's near a Marriott, which is, I think, pretty far away.
You'd like to know the distance. (1945) Savoy Drive. to where?
235 Perimeter Center Parkway, I think it's called.
Looks like it's 2.5 miles.
Right, so this is again, significant distance from the property.
So you didn't take this into consideration because of the 2.5 mile, which you consider to be a significant distance from the property?
Yeah, this would not be, if I'm an apartment manager, or if I'm a criminologist advising an apartment manager about a crime pattern, this is not one I would flag.
Right.
It started way off property, ended up near your property. Your property had nothing to do with its cause.
Okay. Tab number 29, bullet fired through window at 3:40 a.m. Got a call from unit 2314, also the 200 building serviced by the 200-400 parking deck. About a bullet hole in a window. The two guys who live in the unit was not home at the time the incident occurred. Police from DeKalb came out and looked for the bullet. The bullet could not be found.
We discussed that earlier. You know, in my opinion, it's a highly suspicious incident.
Right.
But I won't be offering an opinion on whether it's true or not, but it's clearly an unvalidated call for service. You know, there's a claim of a bullet hole, and then there's no bullet. And there's lots of other things that can make a hole in a window although at 3:30 in the morning, I'm not sure what those would be.
Right. But your same answer with regard to the crime prevention posture?
I looked very closely at this one because there's an allegation of a bullet. Obviously, yours is a gun crime, and it's, you know, in 2008, a few months before your incident. So I definitely looked at it, but it's unvalidated. It's not something that would have raised any flags about a shooting or an assault or somebody hurt or somebody injured either on property or in the garage.
All right. Carrying a concealed weapon. This is September 10th, 2008. Do you recall this?
This is where the guy was caught at McDonald's, I think at 10 o'clock in the morning.
Right.
Where somebody dropped a dime on him carrying a weapon.
Right.
Again, I looked at it. It was a gun-involved issue. It was not an assault or a predatory act of violence of any kind. But there's a guy with a gun. And now he was at McDonald's. The gun was loaded. You know, nobody was shot. Nobody was hurt. There's no assault of any kind, no threat made. Somebody just dropped a dime. It sounds like somebody wanted him to get arrested.
But, well, you said at McDonald's he was actually apprehended at 1850 Cotillion Drive, true?
I could see the report. I thought that he was arrested at the McDonald's.
45. While responding to a suspicious person call from 1850 Cotillion Road, Madison Square, condos, Sharon Pender was approached by this officer and Sergeant Ray Ice. Mr. Sharon Pender was asked for his identification. Mr. Pender pulled his identification out of his jacket pocket. Sergeant Ice went to search Mr. Pender. Mr. Pender then turned his back to Sergeant Ice and reached under his shirt to his waistband with his right hand. Sergeant Ice then grabbed Mr. Pender's right hand. Sergeant Ice then advised this officer that Mr. Pender had a gun. The gun was then taken out of Mr. Pender's waistband. Mr. Pender advised that he bought the gun off the street recently after being robbed and beaten at gunpoint. Also advised that at the time of the incident he did not call police. The gun was loaded with 6 bullets with a hammerback. The serial number, make, and model were scratched off the slide. There was also a serial number on the inside of the grip.
But I think on page 1 it says the incident location or arrest location was 1945, or no, it was, if I could see it.
Sure.
I believe it referred to the McDonald's. Yeah, it's 40 4537 Chamblee Dunwoody Road, which says the incident location.
But the suspicious person call came from 1850 Cotillion Drive. That's
Right.
where the suspicious person was.
Object the form.
No.
You may answer.
That's where the call emanated from. So obviously somebody dropped a dime on this guy, told him where he was, and they found him at McDonald's and they arrested him.
So same answer. That does not impact your
Again,
crime. Let me just.
Sorry.
Your crime prevention posture for the property at 1850.
Again, I'm not
Drive.
ignoring this at all. I looked at it very, very carefully. But nobody's threatened, nobody's hurt, no gun is fired, no crime, no predatory act of violence is committed. The guys reportedly got it for defensive purposes, which is pretty common among these street folks. And the incident location was not the property, was not the apartment complex.
Well, nobody hurt. You're not suggesting it's all right to wait until somebody's killed to do anything about security.
Oh, certainly not, but that's a qualitatively different offense than somebody pointing a gun at you and demanding your valuables and not pulling the trigger. Okay? A guy with a concealed weapon is a qualitatively different offense than the one I just described.
Mm-hmm.
This is a guy with a concealed weapon who has it for defensive purposes.
I mean, all offenses are different if you get down to it. I mean, even if you have the same location, you're going to have different times, different people, different ways they perpetrate even the same crime, a robbery, murder, things like that. I mean, that's, as you testified earlier, what you're looking for is something that would alert the property owner to a potential problem that could result in the serious injury or death of a patron or resident. True?
Well, what I'm looking for in a criminological sense, predicate acts of violence. Things that we know in criminology lead to other acts of violence. And you don't have them at the property.
All right. Let's see. Say I've got these. We're gonna mark these as number 11. We can just walk through these incident reports.
What do we got there, Jim?
Incident reports.
Are these all DeKalb County Police incident reports? Look to be.
I'm not sure. I think there may be. Some of these also have internal incident reports, but I'm pretty sure that these exhibits are all police reports.
Were these ones that were previously produced by the plaintiffs?
Yeah.
Okay.
Looking at Exhibit 11, that first incident report, have you seen that before today?
Probably, but it's beyond the 3-year window, so I didn't
Okay.
give it much credence.
Same answer.
Yes.
The next one, simple assault, March 2nd, 2005, 1850 Cotillion Drive. See that one? Pull it.
So, domestic violence, yeah, it's not relevant.
Okay.
And
Now we're up to
it's-
tab.
it's- And it's almost, it's 3.5 years out.
Tab 34. This is March 15th, 2005. Larceny articles from a vehicle.
Same answer, auto burglary.
All right.
More than 3 years out.
All right. Next one, March 18th, 2005, same larceny articles from a vehicle. 1850 Cotillion Drive.
Same answer.
All right. Next one, May 3rd, 2005. Tab number 36. Same answer?
Yes.
Next one, tab number 37. This is, now we're up to August 22nd, 2005. Entering an automobile. same answer.
Same answer.
Now we're up to September 7th, 2005. This is tab number 38. Theft of an automobile, same answer.
Yes.
Now we're up to October 3rd, 2005. Theft of an automobile. 1850 Cotillion Drive. This is tab number 39, same answer.
Okay, this would have been within the 3-year window. So I did take notes on that, but again, it's a stolen car. It's definitely an annoyance, but it's not a danger to a victim.
Nor does it put the property owner on notice that there's an issue with security.
Not in my opinion. I mean,
Right.
and from a criminological standpoint, maybe there's a legal issue
Thank you.
that I'm not
You can yell. I mean, that's. I'm sorry.
that I'm not here to opine about. I mean, from a criminological standpoint, which is why I'm here, there's no correlation.
Right. All right. We're up to tab 40. Now we're up to November 2005. Theft by taking. NCIC operator Alexander was notified. Same answer.
Yes.
Now we're up to, this is April 2005, theft by taking. Same answer.
So again, it's beyond 3 years, and it's the same old auto burglary.
All right, tab number 42, theft by taking, criminal trespass. This is November 19th, 2005. Same answer.
I think this is the one you asked about before.
Let's see. 1850 Cotillion Drive, 1317, Atlanta, Georgia. Incident date November 19th, 2005.
Yes.
Same answer.
Yes.
Tab number 43, dated December 1st, 2005, entering an automobile, 1850 Cotillion Drive, 3321, same answer.
Yes.
Up to tab 44, now December 7th, 2005, theft of automobile, 1850 Cotillion Drive, same answer.
Yes.
Tab number 45. Now, December 29th, 2005, larceny, articles from vehicle, 1850 Cotillion Drive, 3304, Atlanta, Georgia, same answer.
Yes.
Tab number 46, entering an automobile, 1850 Cotillion Drive, 3321, this is Dunwoody, Georgia, 1229, 2005, same answer.
Yes.
Larceny, parts from vehicle, this is 12/30, 2005, so the following day, 1850 Cotillion Drive, 1313, Atlanta, Georgia.
This was the night where there was, I think, 9 separate incidents. So I would say the same answer to all 9.
Okay. 12/30, 2005, 1850 Cotillion Drive, 3419, Atlanta, time 1500. This is tab 48, same answer.
Yes.
Tab 49, 1850 Cotillion Drive, 3205. Again, 12/30, 2005. Same answer.
Yes.
Tab 50. This is actually the tab 50 and Exhibit 10. Larceny, parts from vehicle. Again, 12/30, 2005. Same answer.
Yes.
All right, now, okay, thank you. Now we're going to Exhibit 10, Part 2, Tab 1, we'll call it, because these tabs, they only go up to 50 that we have, so this will go to 50 and it'll go to 50 again, but we're going to call it Part 2, Tab 1.
Part 2 of Exhibit 10, starting with new tab.
New Tab 1. This is also 12/30/2005, larceny, parts from vehicle. Same answer.
Yes.
Exhibit 10, Tab 2. Exhibit 10, Part 2, Tab 2. Now we're up to 6/28/2006, 1850 Cotillion Drive. Aggravated assault, gun, fleeing or attempting to elude a police officer, reckless driving.
This is where somebody fired at the cop off property during a chase. So somebody's got a stolen car. They run. Cops get on their tail. They keep running. And they shoot at the cops during the chase. And that's actually, I tagged this report as a good example of defiance on the part of offenders, despite the immediate presence of a law enforcement officer. So it corroborates from a local level the national and state level statistics, or local level statistics, that I'm going to bring into the case about defiance, which is the third opinion about the functional limits of crime prevention.
How are the functional limits of crime prevention different from deterrability?
I'm bringing in specialized databases from Criminology to show essentially crime in the presence of perfect security.
Thank you. All right, I think we need to take a break.
Going off the record at 2:49 p.m.
Do you want to take a restroom break or something?
On the record at 2:56 p.m.
I'm not sure where we were. I think you were explaining.
The specialized criminological databases to demonstrate the functional limits of crime prevention. You asked if that's to show the opinion of undeterrability. No, it's just simply to show that, okay, not all crime is preventable. And here's the factual basis for my opinion. So these data, actually I have data from DeKalb County Jail. Crimes committed in DeKalb County Jail from I think 06 to 09.
In the DeKalb County Jail?
Yeah, where there's perfect security. Presumably perfect security. I have, and in fact I have notes on that here.
So this is some, do you remember Nick Mortakis in Atlanta?
That name is vaguely familiar. I use this data
Yeah, let's go ahead and mark that one. Sorry.
in fact, I used this data with Judge, I'm sorry.
Go ahead. Yep.
With Judge Purdom in the last,
Yep.
DeKalb County case I had there. This was last year, I think. It was like a rape case at an apartment complex. And so this is exactly the same data I used in that trial. In addition, I'll be using UCR data, which is Uniform Crime Reporting data from the FBI, on the number of police officers assaulted and killed in the line of duty on an annual basis. I'll be using, and that's national data.
Mm-hmm.
I also have access to national data on assaults and crimes committed in prisons outside of DeKalb County,
Mm-hmm.
which I would probably comment upon. Again, just to show that, okay, let's select a place where there's as close to perfect security as is humanly possible, and let's examine whether there's crime there. Let's examine whether there's violent crime there. And I can't imagine a more useful place to examine that hypothesis than prison or jail, where, you know, bars, guard towers, cameras, administrative segregation, you know, every conceivable security measure, fence perimeters, razor wire. I mean, every conceivable security measure that can be taken in a lockdown facility is taken, and yet DeKalb County certainly shows its share of crime in general and violent crime in particular at its facility.
When you say DeKalb County, you're talking about the jail.
Yeah, but I also have prison data nationally to illustrate that, in addition to the police assault and homicide data. And then I'll explain, the reason for crime in the presence of security. It's, two types of defiance: evasion and confrontation. Evasive defiance is, you commit the crime because you think you're going to get away with it because you're smart enough to or you think you're smart enough to do it without security seeing you. Or if it's confrontational defiance, just the notion of you take on security or police because you simply just don't respect their authority. So those are the two primary explanations that criminologists give for defiance. And I probably would also discuss, to support that opinion, Bureau of Labor Statistics data, which show that essentially the security guard police officer occupation is about, it depends on the year that you look at, but it's widely regarded as the second most dangerous job in terms of homicide per capita risk for victimization in the country. Taxi drivers are the first.
And who's second?
Security guards, police officers.
Got it.
Typically, that type of occupation varies a little bit from year to year, but they're typically in the top 3 or 4, if not number 2.
Mm-hmm.
So I'll discuss that data. Obviously, this property, the security guard was there for observe and report. And I don't know what would have happened to the security guard if he would have been present and at the incident location when this happened. But look, these offenders shot the victim to get what they wanted. I see no reason why they wouldn't shoot a security guard. I don't know that, but they've already demonstrated what they want to do and did do. And so there's no reason to believe they wouldn't create another victim. I'll also note in the context of defiance that some of the best available research on robbers shows that unarmed security guards are one of the last things that deter them. Like Rosemary Erickson's research on robbery shows that she rank orders a whole list of measures that are designed to deter robbers in certain situations, and I think unarmed security guards ranked either dead last or next to dead last of what would deter them. And so obviously that is consistent with this data that would support opinion 3 about the functional limits of crime prevention.
All right. I think when we broke, we were talking about tab 2 and part 2 of Exhibit 10. This was the aggravated assault, gun, fleeing, or attempting to elude a police officer and reckless driving.
Right. So the officer gets a low jack hit from a stolen car. Stolen car is near, I guess, exit 30 and 285, which appears to be close to your property. He gets behind the vehicle. The offenders flee. One of the offenders shoots at the police as the chase ensues. So this is a perfect example of defiance, and a perfect example of the database that I will use to educate folks about the prevalence of this kind of conduct among serious offenders.
And how does this incident report behind Exhibit 10, Part 2, Tab 2 impact your analysis in this case?
Just in that way, that it's a perfect illustration from a local level of defiance of the best security, which is arguably an armed police officer following you in a police cruiser. It's a serious crime, but it's off property. It has nothing to. The apartment complex didn't cause this crime. It had nothing to do with the apartment complex.
You think the apartment complex caused Nicholas Surovec's murder?
Oh, I don't think so.
Right. Okay.
I mean, the offenders caused it, right? I mean, they shot him. It's terrible.
How else did it affect your analysis?
That's the principal way that I would use that report.
All right. Then tab number 3, criminal trespass, 1850 Cotillion Drive. This is now August 26, 2006.
Right, this is, the security guard had his mirrors broken on his car at the property.
Right.
And I'm not sure if it was a marked security car. There's no evidence that it was, but it's his car.
And how does that impact your analysis?
Again, it's another auto burglary, or not auto burglary, but vandalism to a car.
You don't ignore it like all the others. You take it into account, but it doesn't change your view that the crime prevention posture at the time of Nicholas Surovec's murder was adequate.
Relative to a robbery homicide, which is what I've been saying the entire day.
Okay, all right. And by relative to a robbery homicide, what do you mean?
Well, that's what we're here for.
Right.
So, that's the question that I address, is what they were doing adequate and reasonable relative to the risk of a robbery homicide. That's the only thing I was asking about. Or that's the principal task of my opinion, was to explore that issue.
Right. But, I mean, so your testimony is that for a property like 1850 Cotillion Drive, you can institute security measures, and the security measures can work for some crimes and not others and still be adequate. Your crime prevention posture.
What I would say is that the multiple measures that they were taking, which is illustrated by the list in 4.4, among other aspects of my documents, clearly shows they're taking a number of adequate and reasonable measures to inhibit offending at their property. And obviously auto burglaries may not have been it's difficult for these types of measures to deter auto burglary, perhaps, but relative to the incident that anchors this case, these are adequate and reasonable measures relative to the risk of this occurring. You have essentially a 3-year history, and I only looked at 3 years, but I think it goes back farther than that, of no acts of predatory violence in your garages and against a resident. And juxtaposed against this list, in my opinion, that's reasonable.
Right. Now on to Exhibit 10, Part 2, Tab 5. Larceny, parts from vehicle, 1850 Cotillion Drive, Atlanta, Georgia. Now we're up to September 23rd, 2006. Theft by taking.
Right.
Same answer.
Somebody took the guy's license plate. Again, these are annoyances. I mean, absolutely. But does it predict a robbery homicide? No. I mean, are these at all useful as predicates to a robbery homicide? In my opinion, based on all the criminological evidence, they're not.
All right.
So, I mean, that's all I can say.
All right. The next one, tab number 6, larceny articles from vehicle. This is now September 22nd, 2006, 1850 Cotillion Drive. Carrie Dolphin. You've seen all these before today, true?
Yes.
Okay. Same answer.
Yes.
Next, Part 2, tab number 7, theft by taking, automobile, stolen vehicle recovered, 1850 Cotillion Drive, 2317 Atlanta. Again, 2317 is also serviced by the same 200-400 deck where Nicholas Surovec was murdered. True?
Yes.
Same answer?
Yes.
Exhibit 10, Part 2, Tab 8, 1850 Cotillion Drive, 2307. Now up to October 27th, 2006. Theft by taking motorcycle. Same answer.
Yes.
Now, Exhibit 10, Part 2, Tab 9. Theft by taking automobile. Up to November 30th, 2006. 1850 Cotillion Drive, 2220. Again, the same building serviced by the 2 and 400 parking deck where Nicholas Surovec was murdered. Same answer.
Yes.
Same answer. Now up to tab 10 of the same part 2, criminal damage to property in the second degree, 1850 Cotillion Drive, 1312, Atlanta, Georgia. Silver Lexus keyed on the passenger side by unknown suspect. Same answer.
Yeah, I mean, this is one where the lady's mad or somebody's mad that this other person's parking in their parking space and they key the car. I mean, it's just silly.
Okay. Tab number 11, theft by taking automobile, 1850 Cotillion Drive. We're up to December 17th, 2006. Same answer.
Right, it's about 2 years before. It's a property crime. It's no violence, no threat, no assault, no nothing.
Okay, next one, tab 12, part 2, exhibit 10, up to January 3rd, 2007, 1850 Cotillion Drive, 3119. Theft by taking automobile, same answer.
Yes.
Next, tab 13, 9 days later, January 12th, 2007, 1850 Cotillion Drive, 3102. Entering an automobile, same answer.
Right, they took the car stereo.
Next one, tab 14, June 7th, 2007, 1850 Cotillion Drive, 3115. Entering an automobile, same answer.
Yes.
Next one, tab 15, part 2, exhibit 10, up to July 9th, 2007, so the following month, 1850 Cotillion Drive, 4104. Entering an automobile, same answer.
Yes.
Tab 16, this is the following day, 1850 Cotillion Drive, entering an automobile, same answer.
If I could back up to the previous one, this is a good example of lock, take, and hide. So they busted the guy's window, and they took an iPod stand, and an Olympus camera from the car. I mean, it's just...
The victim's fault, in part, at least.
I would never leave that kind of material in my car, especially for somebody to break a window and take. I mean, that's crime prevention 101.
Okay. So you do fault the victim somewhat in that situation.
I don't like to blame crime victims, but I mean, the offender did it, but I would never leave that kind of stuff in my car.
Okay. Then and my question is, do you fault the victim in that situation?
Like I say, I don't like to blame crime victims.
So no?
I wouldn't use the word blame, but I hope the victim would use that as an educational experience.
All right. I think we're up to tab 16? 17. Tab 17, which is 2 months later, September 2007, 1850 Cotillion Drive, larceny of articles from vehicle, same answer.
Yeah, laptop, digital camera, CDs, cell phone charger, and Cartier sunglasses.
Okay. Tab 18, now we're, this is the same day, September 9th, 2007, entering an automobile, intent theft, 1850 Cotillion Drive, 2303. Same answer.
Yeah, you got a GPS system, Oakley sunglasses, Samsung MV3 camera. Right, same answer.
Okay. Now we're up to tab 19. Criminal trespass, damage 1850 Cotillion Drive, September 10th, 2007, so the following day. Same answer.
This is, yeah, and in fact, this is an example of one of these crimes occurring with security guard right there patrolling, which is one of the examples I'll use to localize the defiance data.
Okay. Now we're up to tab 20, part 2, exhibit 10, 1850 Cotillion Drive. What's it? 1320, entering an automobile, same answer.
Right, he's got his iPod and his shoes taken from the bed of his truck, or the
Okay.
cab of the truck.
Right. Same answer.
Yes.
We're now up to tab 21, 1850 Cotillion Drive, entering an automobile, same answer. September 29th,
They
2007.
broke, yeah, they broke the window and took a roll of quarters.
Okay. Same answer.
Yes.
Now, next tab, 22, 1850 Cotillion Drive, 3119. Theft of automobile, October 22nd, 2007. Same answer.
Yes.
Now, tab number 23, 1850 Cotillion Drive, 1402. Larceny articles from vehicle. We're now up to November 1st, 2007. Same answer.
It looks like they got in the car and scratched up the seat. Didn't take anything. Yes, same answer.
Now we're up to tab number 24, part 2. Criminal trespass, 1850 Cotillion Drive. Unknown suspect damaged passenger window, 2006 Ford F-150. Same answer.
Right, they damaged the window and didn't take anything.
Now we're up to tab 25, part 2, exhibit 10. November 25, 2007, criminal trespass, 1850 Cotillion Drive. Same answer.
Yes, this lady's car was keyed. Right.
Okay. We're now up to part 2, tab 26, exhibit 10. Larceny articles from vehicle at 1850 Cotillion Drive, 4417, Atlanta, Georgia. Incident date December 3rd, 2007. Same answer.
I don't see that one. Oh, no, I don't see that one. Right, they broke her window and took the GPS.
Same answer.
Yes.
Up to tab 27, part 2, exhibit 10. Criminal damage to property in the second degree, 1850 Cotillion Drive. Now up to January 5th, 2008. Same answer.
Yeah, that one's not in here either. Yes.
Okay. Up to tab 28, larceny parts from vehicle. We're now up to February 11th, 2008, 1850 Cotillion Drive, 1208, Atlanta. Same answer.
Again, that's not in your stack here. I mean, it's in my notes, I believe, but not in the stack. Right, they stole the battery from their car.
And all the research that you've done, have you had folks steal a battery out of a car?
I've seen it. Sure.
Have you ever had someone steal all four wheels and tires off a car overnight?
Yes.
Okay.
Seen that too.
All right. We're now up to part 2, tab 29, exhibit 10, damage to property. This is 1850 Cotillion Drive, 2421. Incident date February 15th, 2008. Same answer.
Right. Yes.
Next one, tab 30, part 2, exhibit 10, 1850 Cotillion Drive, February 15th, 2008. entering an automobile, intent, theft, 16-8-18, same answer.
Right, they broke the window and stole a leather jacket. Correct.
Now, 3 days later, it's now February 18th, 2008, 1850 Cotillion Drive, entering an automobile, intent, theft. Same answer.
Yeah, they broke the window and they don't know if anything was taken.
Next tab, tab 32, Part 2, Exhibit 10, 1850 Cotillion Drive, 2225, damage to property. Unknown subject, damage to tailgate, driver and passenger side doors to 2002 white GMC Yukon. Same answer.
Yeah, the car was keyed, so usually that's some kind of dispute between victim and offender.
Tab 33, larceny, parts from vehicle, 1850 Cotillion Drive. We're now at 4/24/2008. Same answer.
Right, somebody stole the mirror off a car.
Now up to tab 34, Part 2, Exhibit 10. Criminal trespass damage. This happened on June 20th, 2008, 1850 Cotillion Drive, 3106, Atlanta. Same answer.
Yeah, this is an apartment unit where somebody damaged the knob, it looks like. Right.
Now up to tab 35, theft by taking, parts from vehicle, 1850 Cotillion Drive, 2117. Same answer.
Right, they broke the window, they stole the stereo, the amps, the speakers, and tools. Correct.
Up to tab number 36. It's now July 17th, 2008, 1850 Cotillion Drive, 3321. Entering an automobile, intent, theft, 16-8-18.
Right, they
Same answer.
broke the window, took a $300 camera, and a $1,500 stereo.
Would you park at Madison Square?
I wouldn't leave valuables in my car in terms of, parking garage. Really, most any parking garage, I wouldn't want to do that. To leave a valuable in plain sight like that is just foolish. For me to do that would be foolish.
Right.
And it's not necessarily at this location, but just anywhere.
Right. And it doesn't, I didn't see in any of these reports that it said that these items were necessarily in plain sight.
Well, like for example, a leather jacket. I don't know. Would you hide that under the seat?
I don't know.
Well, it's not in the report, but all my experience and all the analysis I've done on these types of crimes, when these auto burglars bust your window in because they see something that they want to take, and it's easily taken.
Right.
So I don't know for sure, but based on all my experience and analysis of these crimes, that's what happens.
All right.
They don't break the windows of cars unless they see something worth breaking.
All right. Up to tab 37, July 18th, 2008. This is actually reported by Roxy Miller. Criminal trespass, damage. Vandalized the firebox on the property to gain access to the parking deck. Call that?
Yeah, I do.
Same answer.
Yes.
Up to tab 38. Part 2, Exhibit 10, 1850 Cotillion Drive, Atlanta, Georgia. September 11th, 2008, damage to property.
Right, this was the only parking garage crime between mid-July, was roughly the time they scaled back security, and your incident date. So this is the only auto burglary, or I guess vehicle-related crime in the garages in my recollection, between roughly mid-July and the incident date, which is close to 3 months, and which also coincides with the reduction in the security guard coverage.
Have you seen a graph that was prepared regarding a reduction in security?
Yes.
Okay. Did you verify that those numbers were accurate, or?
Verify? I mean, I think in the depositions I reviewed testimony, so that would be verification.
Okay. And it looks like I'll just show you. I can pull this up and identify. This has been marked as an exhibit before, but this, for the record, this is the weekly reduction in security leading to Nicholas Surovec's murder. It's a graph.
Prepared by you.
Correct.
Yeah.
Based on information provided by the defendants.
Not sure about that, but in part.
Right, just like I said, the reduction started roughly around mid-July.
Right, but the reduction was actually quite gradual until mid-September, right?
Assuming that they didn't have policemen on site as courtesy officers, because I know there's some testimony, and some of the opponents said that they had phased in these courtesy officers before the security coverage had been fully reduced.
Did you read John Williams' affidavit?
I believe I did, but there was testimony in some of the depositions that seemed to indicate the courtesy officers were phased in before your incident. So I don't know what to make of that conflict.
Do you recall John Williams testifying that Roxy Miller asked him to backdate a lease in order for it to appear that he was there at the time of Nicholas Surovec's murder?
Oh, I don't remember that.
Okay.
I don't remember that.
Okay. Do you recall John Williams, a former DeKalb County police officer, testifying that he was actually fearful of being on the property because of the crime there?
I do vaguely recall that. Was this after the murder?
Yes.
Yeah, well, usually when you have a murder like that, people are very, very scared, although I don't think I've ever heard a police officer say that.
I mean, any reason to believe that John Williams is in any way untruthful or dishonest?
Oh, I don't know him. I'm just saying I don't think I've ever heard a police officer say that.
Right. Anything in any of the records that you've reviewed that cause you to believe that anyone who's testified in the case is being somehow dishonest or untruthful?
Oh, I don't make credibility assessments. I mean, that's not my call. I don't have an opinion on that.
Well, in order to render an opinion, if you have testimony that's an opposite, I mean, I guess you have to make a determination to formulate an opinion at times. True.
Well, you typically look at the preponderance of the evidence as opposed to, assessing the credibility of an individual witness. That's the jury's call. I mean, I look at the balance of the testimony. That's what I do.
All right. So is that graph commensurate with your recollection about the security reduction?
Again, assuming that the courtesy officers were not phased in prior to your incident, and I believe Holstein testified that they were, and I believe I thought Roxy Miller testified that they were being phased in, but I could be wrong there.
All right. Tab number 38. Damage to property, 1850 Cotillion Drive. This is September 11th, 2008. This is one we just reviewed, right?
Yes.
Same answer.
That-
Tab number 39, theft of automobile, stolen vehicle recovered, 1850 Cotillion Drive. This is October 8th, 2008.
That's post-incident, so I would not have looked at that.
Okay. And then by the incident, you mean the murder that occurred on October 4th, 2008,
Right.
true. And reviewing the incident reports that we did, 1 through, I don't know, between 80 and 90, those don't cause you to have any concerns about the overall security at the property over the course of that time?
What I will say is they're not predicates for a robbery homicide.
Okay.
They're just simply not. In criminology, you do not use those to predict or forecast robbery homicides. And at least a few of those incidents occurred where you had exactly what you're saying should have been on property. A guard patrolling the garage. So
Well, I'm sorry.
they're clearly an annoyance. I agree with you. But they're not a danger to
Okay.
the victim.
All right. So you disagree with Rami Rosen in that regard, where he said he most assuredly could envision someone happening on someone stealing a car or property, or someone breaking in when someone's at home and something bad happening.
Object the form of the
First of all,
question.
Give me an answer.
First of all, he's not a criminologist, so
Right.
no offense to him, but he doesn't have access to these databases that we do.
Right.
Secondly, I'm not saying it's not impossible. You're talking about possibilities versus probabilities,
Right.
and the probability is infinitesimally small for escalation. I mean, all the data show that.
Right.
So I'm not saying it's not possible.
Mm-hmm.
A lot of things are possible, but possibility is not one. That's not what I'm in the business of assessing. I'm in the business of assessing probabilities, and it is not reasonably probable for an auto burglary to escalate into, or any burglary to escalate into a robbery homicide.
Right. But the question in this case is a little different. I mean, regarding your role, and that is whether the defendants, the property owners, had adequate security in October when Nicholas Surovec was murdered. True?
Relative to the risk of a robbery homicide. That's what I've been saying all day today.
Right, which is what, I mean, landowners have a duty to protect visitors from foreseeable criminal harm. True?
That's what courts have found, yes.
Right, and you agree with that, right?
Well, I wrote in the context of what courts, it's not my place to say that. I mean, that's what courts have determined around the country.
Right.
That sentence.
Right, and that's what, I mean, that's what you're here to testify about, right?
Object the form. That hadn't been in his testimony. He's already explained that quote that you're taking there.
Yeah, I mean, I don't agree with what you just said. I mean, I'm testifying about a lot of things today.
Right.
But I don't think I'm testifying about explicitly what you just said.
Well, maybe you can help me. My understanding, we just went through a number of crimes today, and I think in your view, the crimes that we've discussed do not make it foreseeable to a property owner that someone would be robbed and or murdered in the parking deck on the property. True?
Okay. You use the word foreseeable, and foreseeable is a legal construct. I'm not in the business of giving legal opinions. I give criminological opinions.
All right.
And so what I do is assess the probability of auto burglary or property crime in general leading to a violent crime. Okay, if you want to call that foreseeability, that's your business. We call it assessing crime data for the
Right.
likelihood of escalation.
Right.
So that's what I do.
Right.
That's my answer.
All right. And did you also look at the physical security at the property, 1850 Cotillion Drive?
Well, I mean, yeah, I mean, you're talking about, first of all, about 94% of U.S. households do not live in a gated community. So the fact that this place is gated and has high-speed control arms on top of the gating, that's extremely rare. I mean, to not only be gated, but to have high-speed control arms to attempt to inhibit tailgating,
That's very, very rare, and that's a
Right.
great measure that they had. You know, in addition to
And were those there in October 2008?
the high-speed control arms,
And the gates?
Yes, because I saw the video.
Okay. And would those have permitted tailgating in October 2008?
Well, look, anybody can ram the gate. Anybody can jump the arm. It inhibits it.
Right.
It's an additional obstacle that offenders have to consider.
Right.
It doesn't. This is not an impervious perimeter. I mean, this is not a prison. And I've said that multiple times today.
Right.
If you want perfect security, you're not going to find it typically at an apartment complex.
Right.
All you're going to find are measures that are reasonably taken to address reasonably foreseeable crime.
Right. Do you recall reviewing the video for October 4th, 2008, and seeing anyone follow anyone else in? What do you call it? Piggyback?
Tailgating, piggybacking.
Yeah, okay.
I don't recall. I know the police. It was hard to tell because the police kind of changed the timing on some of the videos.
Right.
So I don't know if there was piggybacking or not. But
Okay.
if somebody really wants to get into a gated complex, they're going to do it,
Right.
even if there's high-speed control arms,
Right.
and assuming they don't have an internal connection to the property.
Right.
So.
And you reviewed the photographs where the fence on the back of that parking deck could be pulled up and someone could easily get under, right?
Object before.
Are you talking about the chain link with the? I saw the pictures and I saw the testimony about those pictures. I mean, LaDrew Jackson was saying he didn't think anybody could crawl under there, and if they did, they would get injured. So look, I'm not saying that this property was impervious to access.
Right.
If you wanted to get in here and you didn't live there or have an internal connection and you really wanted in, you could find a way in.
Right.
Okay, I'm not saying that this has perfect perimeter security.
Right.
But I think the posture in place, in my opinion, showed territorial reinforcement, defensible space, I mean, access control. These are all principles of CEPTED, which is, you know, a well-trodden intellectual territory within criminology.
Right.
And in addition to all these other things on my list in Exhibit 4.4,
Right.
I mean, these are really good measures. You know, are they useful in preventing all crime? All crime, no. Are some crimes less able to be inhibited by these measures than others?
Deterrable?
Probably.
Yeah.
Do auto burglaries still happen despite the presence of a security patrol? Absolutely. And you had it at least 3 or 4 times on the property. So, again, my opinion is that, I mean, this is not perfect security, but I don't think that's the standard. You know, that's the way I look at this case.
You agree it's not perfect security, but you think under the that it was adequate security.
Yes, because, you know, the core issue is, you know, should they have had a guard patrolling at roughly 2:30 in the morning on October 4th, 2008? And the fact that there wasn't a guard patrolling that night, does that mean that, you know, they should be held accountable for the death of your client? In my opinion, I don't think so, because of the reasons that I've talked about today.
Right. But that's not, I mean, okay. Is that sort of how you see your role, a determination about whether the property owner should be liable for an incident or a death like that?
Well, and I don't mean to do that. I'm just saying at the end of the day, you know, I won't be assessing liability, obviously.
Right.
But as a criminologist, you know, this list is a pretty impressive list. And obviously, I haven't even talked about it today in the deposition, but it's an exhibit, and I don't need to talk about it. But I will say at trial that I will convert this list into some sort of poster board or PowerPoint. So I'm going to tell you right now, so you're not surprised.
Oh no, we use Keynote,
Sure.
but I'm sure. I mean, I don't know. LeBron shared with you some of the stuff. I fully anticipate that.
So I'll put it on a poster board or have him do it, or a PowerPoint with pictures. I probably would request that Mr. Neary and his staff do some sort of mock patrol of the garage to show visually to the jury the difficulty of a security guard being present at the location of the shooting when it happened, to show the difficulty of realizing that the offenders were even committing this crime as they committed it, because they jump in the car as soon as they open the door. So this is not something that is taking place over a long period of time. It's very loud and it's very visible. They're in the car with the victims. So I imagine that some sort of video or mock patrol would be something that I would request that be done as a visual aid for me. And just to show the jury, okay, let's put a guard in this garage or in these garages at the time of the incident, and let's see how effective that would be as a deterrent. Let's let you decide, the jury. And I think just having recognizing, if we assume, as your expert did, that we needed a guard.
2 guards.
No, he said 1 guard in the garage.
Well,
Okay.
A total of 2 guards.
2 total.
Which is also what, you saw Tom Savoy, you read his deposition today?
Yes.
He also said that at the time, Crown Solutions was suggesting 2 guards, true?
He said a lot of things.
Do you recall that or not?
A lot of which were unintelligible. He said both, I believe. He said they needed someone, and then he said they didn't need somebody. He said both.
Well, do you recall his testimony about Crown Solutions suggesting to the property owners that they needed 2 guards? 1 was not enough. And him basing it on his experience, he was actually on foot there.
Well,
Object to the form. Not sure
he
that's
said that,
exactly
and in
his
other
testimony.
places he felt that security was fine. As I recall reading his deposition.
All right.
Again, he's all over the place. I'm not sure what to make of him.
And you read his deposition, I mean, in 45 minutes
About
today?
an hour.
Okay.
But yeah, he's all over the place. But your expert, assuming that position, you put 1 guard in these 2 garages, I would think the jury would be interested in showing the potential effectiveness or ineffectiveness of 1 guard in 2 garages during the time frame it took for this offense to unfold, and the way in which this offense unfolded inside the interior of a car where these victims were snuck up upon, and where the shooting materialized relatively quickly after they were told to exit the vehicle.
All right. You didn't prepare a report, true?
Correct.
Are you going to prepare a report?
Not unless I'm asked.
You agree that criminology is an interdisciplinary field in the behavioral sciences, drawing especially upon the research of sociologists, particularly in the sociology of deviance, psychologists and psychiatrists, social anthropologists, as well as on writings in law?
I would say criminology is a scientific study of the causes, correlates, and control of criminal behavior, and that's the standard definition of criminology. What you got at is, I would say, tangential. I would say my definition is probably the more relevant and appropriate definition of criminology.
All right. Do you have any criticism of Nicholas or Krista Surovec and the way they handled this situation when they were attacked by these gunmen?
I don't think so. I'm not going to blame the victims. The only thing I would say is what I said earlier, is that if there's resistance during a robbery, the best available research shows what's a normal kind of street victim, 16 times more likely to be killed than when resistance doesn't occur. So that's not criticism, that's just a data point.
Right. I mean, if you've never been with you're married, right?
Yes.
You've never been attacked in the presence of your wife and had a gunman, threaten to take your wife off to a room. True.
Correct, and that's why I'm not criticizing him at all.
Okay.
At all.
And you have no idea how you would react in a situation like that.
No, it's a tragedy. It really is.
Let's see. We've got your CV. We'll go ahead and... Did you bring a copy of your CV?
I emailed it to him yesterday.
You get that one I forwarded to you?
Yeah, I mean, I've
I don't know
got
if you
a couple
had
different ones. It doesn't matter so
chance
much
to
to me,
print it
but we can use this one. Show you what's been marked as Exhibit 12. This is your current CV.
Yep.
Okay. There's just a couple of questions. The articles that appear to be relevant to Nicholas Surovec's murder and this case are on page 5, foreseeability and duty of care in third-party premises liability. That's the brief published by the American Bar Association, Winter Volume 35, pages 54 to 61. Jacobs, Bruce A. 2005, when is crime foreseeable? For the defense, June 18-20, pages 57-8. Jacobs, Bruce A. 2004, the undeterrable offender and your client's liability for the defense, April, pages 16 to 19.
Those are three among many. I mean, those
Okay.
are trade publications that are peer-reviewed, but they're not in the domain of criminology per se. They're trade publications that are, well, they are criminological articles, but they're not double-blind peer-reviewed in the sense that my other research is.
All right, well, the 4 books, let's see, the ones I looked at, Investigating Deviants, anything in there that's applicable to your opinion in this case?
Well, I mean, again, that's an edited volume,
Right.
so I'd imagine there's some pieces in there that are relevant to, look, it's all part of my background, so I can't just say that this article is not relevant and this one is. I mean, everything I've ever done has informed the opinions or the way that I view the data today.
Right.
And so, you know, I'm not going to say that this article or this article isn't relevant. You know, it's a career's worth of work, and so it all informs my perspective that I bring today.
And what I'd like to know is what treatises, textbooks, articles, chapters in textbooks, peer-reviewed, non-peer-reviewed, not something like in the grand rounds, throwaways, that you will refer to or use in your testimony when we try this case next month.
Well, for example, on the issue of offenders, property offenders not wanting to confront victims,
Right.
there's a rich array of studies in criminology that explore that very issue from the offender's perspective. So Wright and Decker, burglars on the job, Cromwell and Olson, breaking and entering. Those two studies are kind of authoritative treatises on the issue of what offenders do, what property offenders do to make sure the victims aren't around when they target your dwelling or
Right.
your whatever they want to steal.
That's fine. What else?
National Crime Victimization Survey, which is a national database that explores the extent to which property crime is accompanied by violent crime. The NIBRS database, which I talked about
Right.
today. Obviously the UCR, which I've talked about today.
Right.
The DeKalb County jail data, which I've talked about, and
Right.
I'll bring into play.
Right. Do you have that here?
Yes.
And we asked for it. You I'll go ahead and Exhibit 1 is your notice of deposition. All notes, diaries, letters, you brought all, everything
I brought my
responsive.
file out.
Okay. Let's see. All documents consulted or referred to or otherwise utilized in connection with the preparation.
Well, like for example, the NCVS is a huge document, so
Right.
I didn't download and print it, but I reviewed it. It's, you know, it's a huge database.
But you're only using a small portion of it.
Well, yeah, I mean, it's a sample of, what, 100,000 people, and there's data covering hundreds of variables. So, yeah, it was just, I guess,
All
a
right.
fraction, but
What other treatises, textbooks, chapters, articles, peer-reviewed or not?
okay, here's this Exhibit 4.5. That's the crime committed in DeKalb County Jail.
Let me see. You know what? You mind just reading what that
Sure,
says?
I mean, this is basically between 06 and 09. In DeKalb County Jail, 3 rapes, 5 escapes or attempted escapes, 5 inmates caught with weapons, 8 assaults or threats of corrections officers, 47 threats of bodily harm, 116 directive violations of the staff, and 1,000+ fights or physical altercations between inmates. And that facility has armed guards, razor wire, iron bars, surveillance cameras, locks, steel reinforced concrete, constant surveillance, and administrative segregation. And then this page, I guess, this is the UCR page, which references all the money, and
Let's go and mark that as 4.6.
so this is just national data on the number of police officers assaulted in the line of duty, number killed. The fact that nationwide there's 700 people killed inside prison, so that's prison level data. So this is a combination of police and prison data that help to provide a factual basis for the opinion that not all crime is reasonably preventable, even in the presence of perfect security.
Now, don't you, I mean, if that's your control group, I mean, is that really analogous to society where not everyone in that confined area has a history of criminal convictions?
Right, but they're the exact kind of people who committed this crime. I mean, 2 guys with guns
Right.
who shot and killed this person
Right.
during a robbery. This
Right.
is exactly who populates these prisons. Exactly. And this is why this is where these people go, assuming they're caught after they do what they do.
Right, but these people in prison, theoretically, they cannot leave, true?
Correct.
Now, unlike 1850 Cotillion Drive, when someone, as you so aptly have written, can always go to a softer target, true?
Say again now?
You mind reading that back?
So unlikely 1850 Cotillion Drive, when someone as you so applicably have written
That's
can
right.
always go to a softer target, true?
Aptly, APTLY, I think, but
You mean the offender could go somewhere else?
sure. I mean, we can pull some of the articles that you've written, and you talk about criminals or would-be criminals will, other things being equal, choose a softer target rather than one where there's a security force or a police officer. True,
If they're deterrable,
right?
sure. I mean, if they're not sensitive to risk, they don't care. So it depends on their level of sensitivity to risk.
Right, and someone who's sensitive, well, someone who's not sensitive to risk, would not necessarily wear hoodies, break out the rear view mirror, keep the faces covered, lie in wait at night when it's dark out, not near a police officer, not near anybody else, not,
Well,
etc.
that's fine. I mean, what I would say to that is that there's a number of, and again, I'm not offering this opinion to a jury, but you asked. I mean, there's a number of indicators that suggest the opposite. So you commit a crime in a garage where there's a relatively high intrusion potential. In other words, anybody can drive in, anybody can walk in at any given time. There's at least 30-foot candles of light in that garage based on all my experience in taking these readings and looking at light measurements of other properties.
Did you take readings?
No, because it was 5 years after the fact. Okay. But when I look at the pictures, the crime scene photos, and compare them to my understanding of light, I mean, that place was well lit. So that's extraordinarily risk insensitive. Thankfully for your client, they left her alive, but leaving an eyewitness alive is another risk insensitive maneuver, especially when you're not masked, which is a fourth indicator of risk insensitivity. Right. And then I guess those would be the four. I mean, to shoot as many times as they did.
Do you know how many shots were fired?
I believe 6 to 8. In that kind of lighting, and there were people, witnesses around. I mean, there are people that heard and were awake and around at the time.
Have you listened to the 911 calls?
I believe it was part of the police file. It's not something that I really factored into my analysis in terms of predicate crime and such.
Were you aware that the ceiling height in the parking garage made it inaccessible to an ambulance?
I'm not sure. That didn't factor into my opinions. I mean, that's not something that I would.
You heard that for the first time today?
I think I've heard it before, that it was 6 feet high, but it's not. Again, I'm not an ambulance expert person.
All right. Do you know Dale Wonderlet?
I don't.
Do you know of him?
No.
Do you know Jeff Gross?
No.
Do you know of him?
I've heard of him.
Okay. Ever worked with him?
Jeff Gross?
Yes.
No.
Do you respect him as a...
I just don't know him. I don't know. I have no opinion either way.
Okay. Have you had any conversations with anyone regarding this case?
Oh, sure, Mr. Neary.
All right. Tell me about those.
Just general impressions, all the stuff that I've been talking about today.
How many times have you met with Mr. Neary?
Well, we met on property with Mr. Dykeman.
Okay.
On, I guess it was February 2014.
Okay.
We've had assorted phone conversations over the months. That's about the extent of it.
What's your total bill? How much?
I have not sent an invoice.
Okay.
Yet. I don't even know if I received a formal retainer. I'm not sure. I think I did. I just don't remember.
Did you bring that here today?
I haven't invoiced anything, so I didn't bring any billing.
Okay. How many hours do you have?
At least 35, probably more.
35 plus, and that's at what, $2.50 an hour?
Correct.
And how much do you earn annually doing this type of work?
I have not totaled that. I think I looked over a 10-year period, and I think it averaged around 30%, somewhere north of 30% over that 10-year period.
30%
of my total income. But I think it was more than 30%. But it was over a 10-year period because I was asked that a few times, so I kind of looked at it.
How much did you earn last year as an expert?
I don't know. I give my tax information to my accountant. They fill it out. The return is signed electronically, and that's it.
How many hours did you do expert work in 2013?
I don't know. On average, I spend probably 1 day a week.
Okay.
On this expert or litigation work.
So it's 8 or 10 hours a day?
Could be more. I don't know. On average, I have formal written permission from my university.
Right.
It's at 1 day a week.
Okay.
But I'm not certain what the total is for a year.
Well, if it's a day a week, it's 50 or 52 weeks in a year times 8 or 10 hours. That's what, 500 hours a year, roughly.
Again, I'd be guessing. I would. It's not something that I keep track of.
Well, your best estimate is a day a week.
Again, I'd be guessing. It'd be a guess.
Okay, we can send you a subpoena for those records. You could get those together before trial.
My tax returns?
Tax returns or whatever documents you
Why
have.
are his tax returns?
I'm not providing you my tax returns,
I've
so
never
that's
heard
not
of
going to happen.
Any
That's private
expert ever
information.
given anybody any tax returns?
Well, we're entitled to know, what your earnings are doing this type of work.
I told you that over a 10-year period, on average, I believe was somewhere north of 30%
30% of what?
of my, I believe, my total income.
What was your total income?
Oh, I don't know. I don't know. But when I'm typically asked this question is it's a percent of my income. I don't believe I've ever been asked like for an actual figure. Like you're asking me, I don't know if that question is allowable. And in Texas it's not.
I assure you
But
it
you're not
is.
going to get my tax returns, I'll assure you that.
Okay.
That's private information.
So you don't, your best estimate, which it seems like you backed off that a little bit, was 8 to 10 hours a week?
I don't
in
know.
2013.
Because sometimes I work on the weekends. But one day a week is kind of the average
Okay,
of what I'm permitted.
all right. So that comes out to 520 hours a week if it's 10 hours a day.
I mean, a year.
I mean, I don't know how many times you want to ask me that question. I mean, I'd be guessing. Okay? Sometimes I work a day a week, sometimes more, sometimes less.
All right.
Sometimes I work on weekends, sometimes I don't. Sometimes I work at night during the week, sometimes I don't.
Well, you record the time that you work, right?
For a particular case, sure.
Right. And you compile that somewhere.
For that particular case, I do, sure.
Right. Well, for all the cases.
No, I don't. You mean like, no. If I have a case, I have a timesheet,
Right.
I invoice the attorney for that case, and that's it.
Right.
I don't
well,
have like a master database of, no.
But you track what you bill each defendant that you do work for, right?
Do I track it? It's on an invoice.
Right.
That's about it.
And you work primarily for property defendants in premises
Not true.
cases.
I generated a list for a federal case last year in Jacksonville, Florida, and I think based on that list, I think it was 60-40, 55-45.
60% what?
Defense plaintiff.
Okay.
I think it was 55-45, that list.
All right.
So I do a fair amount of plaintiff work as well.
Okay. Have you ever done work for a plaintiff in Georgia?
I'm not sure. Most of my plaintiff work is in Texas because they tend to hire you local.
Right.
But I don't remember. It's possible, I just don't remember.
Have you ever worked with Brian Neary or Marvin Dykeman before?
No, sir.
What about Billy Gunn?
A long time ago.
And in Florida?
Yep, he was. Yeah, that was a case where the offenders attempted to kill this woman to avenge a drug debt owed by her boyfriend, and that particular piece of information didn't get in, and the jury was not able to consider that. But I do remember that case, yeah.
Right. And the jury, you testified in front of a jury.
Correct.
And the jury returned a verdict.
Correct.
Do you remember that number?
It was high, and understandable given what they weren't allowed to hear. Absolutely.
Understandable. Does $14 million ring a bell?
No,
You don't remember that number?
I do not.
Okay. Conversations with anyone else regarding this case?
Well, it's possible. I mean, maybe I talked to my wife about it. I mean, I don't know.
Anyone else?
Not that I recall.
Right. Documents you reviewed, you've got those, Exhibit 4 here. This is, these are your notes, right?
Among other things, yeah. I mean, there's other things in here, but
And then we've got Exhibit 9, which are the police reports that you reviewed. Right.
Well, there's police reports. Some are police reports,
Incident reports,
some are
police
incident
reports. These are the documents you reviewed, right?
Yeah, among other things.
Okay.
There's a lot of material here.
All right, well, then we've also got the depositions. We'll mark that stack as number 13. You mentioned there were some notes.
Actually, you've already marked that stack.
What's that? Oh, okay, this is part of that stack. So,
Yeah, take that 13 off.
So it's 7.
7's the depositions, and
And on top, there's some, I guess, handwritten notes.
he didn't print off all the depositions.
What's that?
But they're not all the depositions he looked at.
Well, I'll say Brahmi Rosen, right?
And Savoy.
Your testimony is now that you read Tom Savoy's deposition before today?
No, I said I read it at lunch.
Right.
Yeah.
So,
And it didn't change any of your views?
frankly, I couldn't make a lot of sense of what he was saying. He's maybe the video would make more sense, maybe not. He's all over the place. I've never seen a witness say those kinds of things. It's bizarre.
Have you ever had a case that involved spoliation before?
I don't think so.
All right. Are you aware that there was a ruling that the defendants and or their counsel spoliated evidence in this case?
I object to the form. I don't think that's accurate.
I've seen a flurry of documents exchanged between you and the other side. I don't think I ever recall a judge saying that. I think he said he would revisit the issue.
Oh, you mean, well, there's an order holding that documents were spoliated in this case. There's a separate order awarding the plaintiff $15,000 in sanctions for the spoliation. You weren't aware of that before today?
Wait, let me just state an objection to the form of that question. It's not accurate. But go ahead.
I'm sorry, the sanctions were actually $14,700 and something. If my memory serves me, but between $14,000 and $15,000.
Still object is inaccurate.
Yeah, I mean, look, that's between you and him. I just analyze what's provided to me. I'm not involved in these document fights, so I don't know. I mean, I review discovery that's provided to me in the case.
Right.
So I don't withhold discovery. I review what's provided to me.
Right, and it's your understanding. All right. Do you remember who you first spoke with about this case?
Mr. Neary, I believe.
All right, tell me about that conversation. And let's go ahead and mark, what was that? We'll make that 4.7. You mind reading that?
It just says 10-808, but I think it was 10-408. 3 a.m., access gates, key cards, Madison Square, Dunwoody, 300 plus units, I-285, Dunwoody police, 2 shooters, not caught, surveillance cameras on exit.
Okay, and those are the notes you made from the first conversation?
I believe so.
And you've got up here 0.55 hours with a scratch through it, is that?
That must have been, sometimes I use paper within a file to mark down time as I'm doing it, so I don't know if that's related to.
And it looks like there's a 1:1 or 9:19. Is that
Again, maybe
significant?
I use this as a scratch timesheet or something in the file. I don't know. I don't remember.
Have you ever employed security guards?
Have I ever employed them?
Yes.
Personally, I don't think so.
Okay. The textbooks that I was able to find that you'd authored: Dealing Crack, Street Justice, Robbing Drug Dealers, and Investigating Deviants. Dealing Crack, there's nothing in this case that suggests that there was any crack dealing involved, true?
Correct.
There's nothing in this case indicating there was any street justice, or I think what you indicated, I don't remember how you phrase that, the retaliation in the underworld.
Retaliation in the criminal underworld.
Criminal underworld.
I don't think there's any reliable evidence that this was a retaliatory crime.
All right. No evidence that there was any that this was an incident of robbing drug dealers, true?
No evidence.
Okay. So those are 3 textbooks. None of those would be applicable here, true?
I wouldn't call them textbooks, they're research monographs. A textbook is a different animal. Those are research monographs.
Okay. None of those would be applicable to this case, true?
I would say that the crime doesn't appear to be a drug deal, doesn't appear to be a drug robbery, and it doesn't appear to be retaliatory. But I won't say that those books aren't relevant. I mean, I've interviewed hundreds of offenders, and those books canvass the literature on offender decision making and inform a lot of what I discussed today. So I think they're relevant in that regard. But the more narrow question of, was it a drug deal? Was it a drug robbery? Was it a retaliatory crime? I don't think any of those are true. There's no evidence that they're true.
All right. And I mean, your book, Investigating Deviance, any of that applicable to this case? And if so, what?
Well, again, it's an edited anthology. You know, perhaps there are concepts in there. I mean, you're talking about a 500-page book here that contains an enormous amount of material. Both theoretically and empirically, so I'm not going to say. Is there something in here that I'm going to pick out and use at trial? Probably not, but again, it informs my overall perspective in criminology.
Right. Did you watch any of the news articles or read any news reports regarding this Nicholas Surovec's murder?
I don't recall.
Okay. You understand your deposition is a public document?
Yes.
And it can be reviewed by your colleagues, your students?
I suppose. Usually it's just lawyers, but yeah, if it's a public document.
Could be seen on YouTube.
I didn't know that.
Okay, it's public. And your testimony today stands for you.
Sure.
Right. Any conversations with Krista Surovec?
No.
Okay. Never met Nicholas Surovec, right?
No.
Do you know anything about Nicholas Surovec?
Like what? With regard to what?
What do you know about him? Tell me everything you know about him.
Well, I just object to that's a very broad question.
I mean, I don't know. I mean, he was a cook at a restaurant. He was studying for culinary school. Relatively young guy,
Right.
married, from Ohio. I guess had an insurance settlement of some kind where he bought his car. That's about all.
Mm-hmm. You don't know the killer's age, true?
I think the witnesses testified that they were relatively young, 20s probably.
All right. You don't know their race?
Your client said she thought they were black, but wasn't sure.
All right. What about whether they were on any drugs or alcohol? Thank you.
No evidence either way.
All right. Any health issues, psychiatric issues with either of the assailants?
It's unknown.
Four things you look at when assessing crime prevention posture or personnel. Is one true?
I suppose.
All right. And that's by personnel, you're referring to security personnel, true?
Could be management, it could be maintenance, could be other forms of guardians. Doesn't have to be security.
But there was no crime prevention personnel at the time of Nicholas Surovec's murder, true?
I would say there was no security guards patrolling the garage at the time, and that's well-trodden ground.
All right. Social control, there were no bystanders when Nicholas Surovec was murdered, true?
Well, your client was a bystander.
Right. Anyone
there.
else?
Was it Tika Matthews was nearby, or was it?
She was in an apartment.
There was a couple of people who heard the incident, didn't necessarily see it. I don't think there was anyone right around the shooting when it happened.
Which, that's by definition a bystander, true?
Well, you asked about informal social control, and that gets into a whole other area, which is intrusion potential in addition to witnesses. So this is clearly an area with a high intrusion potential. It's a parking garage.
Any witnesses other than Krista Surovec?
Not that I recall.
Right. And the crime in and around the area, you said that you didn't look at crime in the area other than on the property, in this case, true?
There were a few reports of crime like you brought up today, a few reports of incidents, I guess, around the property. I reviewed those, sure.
Right. Well, but unlike in the Ham case, you remember the Ham case?
Mm-mm.
Okay. Well, you didn't do any security assessments at nearby properties, true?
Correct. Okay, this
Nor
is,
did-
if I can remember.
Nor did you do surveys for crime in the area, true?
I told you earlier that I believe there wasn't a sufficient density of complexes in the area to warrant a comprehensive audit of proximate properties.
Okay. There were no police at the scene of the murder, true?
And if I could amplify, I think that Ham case, boy. Yeah, the Ham case, there's a very high density of complexes right around this property, as I recall.
Okay. There were no police at the scene of the murder, true?
Correct.
No security nearby, true?
As far as I can recall, correct.
No one else in the garage at 2:40 that morning, true?
As far as I understand that, correct.
All right. Thank you. There were no patrol patterns at the time of Nicholas Surovec's murder because there was no one patrolling, true?
Right, at the time of the incident, there wasn't a patrol, so yeah, you're right.
And that's another, are you familiar with a DEGI log? Do you know what that is?
Sure.
Now, were you provided with the DEGI logs in this case?
No.
All right. And the DEGI logs are what would enable you to determine what the patrol pattern was at 1850 Cotillion Drive, true?
When?
When someone's using the DEGI system.
Presumably.
And that's one of the indicia that you consider when you make a determination about crime prevention posture, true?
The patrol pattern?
Yes.
Yeah, if it's available, sure, I'll look at it.
All right. Okay. All right, let's stop. I think we're close though.
Going off the record at
I'm gonna mention
4:17
right quick.
p.m. We're on the record at 4:23 p.m.
You haven't authored any textbooks, true?
I would say this is a textbook. It's an anthology.
Okay. Other than the anthology entitled Deviance, which we've marked as Exhibit 2 to your deposition, any other textbooks?
What's called investigating deviance. No, I mean, most of my research, or most of my publications in book form, are research monographs, original research, peer-reviewed, as opposed to a textbook.
Right. Someone trying to call. Okay, any chapters in any textbooks other than this investigating deviance in ontology?
If you look at my CV, I believe a number of my publications have been reproduced in various textbooks. So you could consult the CV.
All your articles are listed in your CV?
All the peer-reviewed articles, yes. Since I've been a faculty member, PhD, yes. There's probably a couple as a grad student very early on I didn't list.
All right. You agree that risk factors associated with armed robbery include a porous perimeter and no security or zero foot patrol?
It depends on the property. It depends on the crime pattern at the property. I mean, those risk factors alone, divorced from all context, are not necessarily explanatory.
Well, okay, 1850 Cotillion Drive. Do you think armed robbery is more likely or less likely with a porous perimeter and zero security on the property?
Depends on whether the offenders have an internal connection to the property. And if they have an internal connection, porosity is irrelevant.
All right. And if they don't?
If they don't have an internal connection to the property, depends on the offender. Some offenders will look at access gates and a high-speed control arm and gating around the exterior of a property and say, you know, I'm going somewhere else. Others won't. It just depends.
To a softer target, right?
It depends on the offender.
Softer target is where they would go, right?
It depends on the offender.
What do you mean it depends on the offender?
I thought I just explained it. Like, some offenders will look at access gates and high-speed control arms and an enclosed perimeter and say, I'm going to go somewhere else. Others won't.
That depends on the deterrability, is that right?
Certainly, yeah. If you want to do an analysis of each offender, certainly. Some offenders are risk sensitive, others aren't. Just depends.
And the two young men who murdered Nicholas Surovec, were they risk averse or no?
I've already answered that question. There's evidence pointing toward risk sensitivity. There's evidence pointing against it. But that's not an opinion that I'll be offering to a jury.
So you don't have an opinion in that regard?
As I said a few times today, I'm not going to be offering the ultimate issue opinion on the deterrability of this crime.
Well, it's the deterrability of the killers.
Well, that's who committed this crime.
Right. How much time did you spend at the property?
I was there, I'm not sure, I was there, I did my site visit on a one-day basis. Came in the morning, left at night, so I don't know how long I was there.
Was it more than an hour, less than an hour?
It's about more than an hour.
More than 2 hours, less than 2 hours?
That's all I did that day, so definitely more than an hour.
All right. Did you take any photographs while you were there?
No.
Did you make any notes while you were there?
Maybe a few.
I'll see those.
Like I just counted off some linear feet in the hallways of the buildings.
Mark that as Exhibit 4.8. It looks like here you've got one BLDG, one building, and this is dated 2/24/14, which is February 24th, 14. What is that one building at the top?
Well, there's 4 buildings, so I went to one of the buildings. I was just kind of curious of the linear feet, the layout of the buildings, how long it would take for somebody to walk up and down a hallway, up and down a floor. That's all.
Okay. And why were you interested in that?
Why was I interested in that? For example, if I was a security guard walking that hallway, how long would it take me to walk a hallway?
Mm-hmm.
How many floors would I have to walk? So I was just getting a sense of the length of the patrol
Right.
for a building. That's it.
And what did you determine the length of the patrol for a building to be?
I don't think I did that. I think I just counted off the feet.
Did you read that?
I'm sorry?
Will you read what you wrote?
Sure. One building, entire hallway, approximately 400 linear feet times 4 floors equals 1,600 linear feet, plus a stairwell, 17 steps times 4 per side times 2. So it's just notes for me to have a sense of the physical layout of the buildings.
Was this part of that? 4.9?
No.
Okay, what is this?
These are just the, it's just a very short summary of the 3 opinions that I'll be offering. And obviously a bunch of data points that are not on that page, but...
Right. Will you read that?
Sure. The best available criminological data and research indicates that burglaries are not predictive of robbery homicide. 2, the crime prevention posture at the subject property was adequate and reasonable relative to the risk of the subject incident occurring. Perfection is not the standard in parentheses. 3, not all crime is reasonably preventable, and I will relay specialized criminological databases as well as examples from the property itself as exemplars of evasive and confrontational defiance. And then the bottom, I just wrote a point here: security guard, observe and report only. And that was made clear by. So that's not an opinion. That's just a little note that I wrote to myself.
And those are your opinions in this case?
I would say that those are very succinct summaries that will orient my testimony. There's obviously lots and lots of data points that fall under those 3 opinions that I've talked about at length today. But as a concise, very brief summary of my 3 opinions, that would be it.
What opinions do you have that you haven't shared with me here today?
I don't think there are any. I mean, you know, I would call them data points that support those opinions, and we've talked about those data points at length today.
All right, and you're thumbing through your notes. You have notes regarding the data points?
Just in my working file, and just in, again, I think we've covered all this.
All right. Now, in the Idri versus Marta case, you interviewed the perpetrator, true?
I did go to prison and interview him.
And when you interviewed the perpetrator, you didn't tell him who you were, true?
I think initially I went in there and got his side of the story, and then I think later in the interview, I don't recall. I know there was initially we didn't want to bias his response, but I think later in the interview, I don't recall. It's been so long. I obviously told him I was a criminologist, and I told him my name. I mean, yeah, of course, but...
You just didn't tell him you were working on that case because you didn't want it to influence what he was going to tell you, I think is what you testified to.
Probably. At least, I think later in the interview, I think that might have come up, but initially, you know, wanted to get an unbiased response from him.
And you did a crime pattern analysis for that property.
For which property?
For the Marta property where the crime occurred in the Idri case.
I think it was Peachtree Station.
Peachtree Center.
Yeah. So I think we looked back 3 years.
Right.
At that property.
That's right. So 3 years was the appropriate time.
2 to 3 years. I mean, 3 years is kind of the published guideline from OSHA. 2 years is the published guideline in peer-reviewed criminology journal. You know, 2 to 3 years is fairly standard.
And to do that, the variables that you looked at regarding crime were the category, the type, the place, the location, the time, the victim-offender relationship, the motive, the weapon involvement, serious injury, and periodicity.
Periodicity, that's so the time period in between offenses.
Right.
Yes, those are all relevant variables.
And you made the same analysis in this case.
It's a standard criminological tool.
Right.
And I would probably apply it to almost any case where I'm assessing the probability of an incident based on prior occurrences.
And that's what you would have used to make the determination that the crime prevention posture was reasonable when Nicholas Surovec was murdered at 1850 Cotillion Drive, true?
Well, it's part of the opinion. It's not all of it.
It's part of the analysis to form your opinion.
Yes, I mean, obviously there's probably 2,000 pages of depositions that are reviewed in addition, some of which contain material about the crime prevention posture of the property. So it's not just that, it's not just the crime data, it's all of it.
Typo. Thank you. Perfect. Well, I'm going to make this number. Number 14, which appears to be an appellate opinion, Amanda Ham versus Equity Residential Property Management Services. You were an expert in that case, right?
Yes.
And you provided an opinion in that case?
Yes.
And the appellate court cited your opinion in that case, true?
Presumably, yes.
Do you mind taking a moment and reviewing that, if you need to?
Sure.
And what was your opinion in that case?
As I recall, this case, this was a case where, boy, this has been a while. It was a shooting inside an apartment. And I believe the apartment complex never provided any notices like the ones we've seen in this case of prior offending at the property. And so I know that was an issue in the case, but I can't recall. Oh, and right, the offender, this unit was right outside the gate, and the gate was not working at the time of the incident.
And what type of incident was it?
It was a shooting inside the apartment.
Did it result in death?
No. And this is a complex that, okay, there was a lot of apartments around this complex.
All right.
And this is a complex that also had significant outreach to these other complexes where they, as I recall, talked to these other complexes about crime in the area.
Right.
And so that was at least part of the reason for surveying these other complexes for crime data. Because they had outreach.
You were an expert for the plaintiff in that case, true?
Correct.
And in that case, you surveyed other property for crime data, true?
I believe so. Because of the outreach, or at least that's one of the reasons.
Right.
And I've seen no evidence of outreach in this case.
Have you spoken with any of the property managers or property owners?
In this case?
Mm-hmm.
You mean this one right here?
Yes.
I think I had my assistant.
Let me be clear on about this case. What are we talking about?
Talking about this hand case?
Oh, Krista Surovec.
Oh no. Like I said, I think initially we looked at that and discovered that there wasn't a density of complexes in the immediate area. So I don't have any record of approximate property analysis.
Right. But in some of the records that you did see, there was crime on in nearby apartment complexes that you did not consider in this case that you did consider in the Ham case, true?
You showed me a couple of reports of crime in the area, I think one of which occurred at an apartment complex. So, yeah, that's true.
All right. In that case, you also had your opinion included the following. Defendants, one, did not have a sufficient notification policy to inform residents of criminal activity at the complex. Two, had burned out lights, holes in fencing, and an inoperable gate at the complex at the time of the shooting. Three, had awareness that criminal activity increases in the summertime and when the gates are not functioning properly. Four, had no security patrol working during the summer. And five, was aware of prior criminal activity similar in nature in the days, weeks, and months preceding the shooting. True?
I believe so. Yeah, I'd like to see it.
Sure.
Okay, this is a pleading on the part of the attorney.
No, that's a Court of Appeals opinion.
Well, it says here specifically she contended 5 acts of omissions were the cause of her damages.
Well,
This is not from a report that I generated.
Those were not your opinions in that case?
These 5 opinions?
Yes. No. Okay. If you turn to page 4 of 8 of that opinion, it reads, in Ham's summary judgment response regarding her negligence claim, she contended, quote, thus defendant's failure to secure the premises and remedy lighting, fencing, and gate issues are the proximate cause of the initial burglary and subsequent shooting of Amanda Ham. Exhibit N. Exhibit N is the report of Bruce A. Jacobs, PhD criminologist. That's you, right?
Well, that's a summary rendition by the attorney of the overall issues in the case. I'd have to reread my report to say if that's specifically what I said. Exhibit N apparently is not attached here, is it?
It is not, but we can pull it for trial, for sure.
Yeah, look, I mean, this is what the attorney is saying in his pleading, and I don't know if it's in my report or not. What I will say is that the police officer who responded to your incident said all the gating was in place, everything was functioning, all the doors were secure, the lighting was clearly excellent based on the crime scene photographs, and there's no evidence that any offender in your case got through some sort of breach and offense. Everything was found to be secure. So you can pull what you want, but in your case, it doesn't seem like any of that's relevant.
All right. Do you remember Perez v. D&T Global Star?
Vaguely.
All right. In that case, you looked at 11 other complexes. You included those in your study, even though they had no violent crime at all. True?
No, that's not true.
It's not.
A number of the complexes, I think the complex at issue had the highest violent crime of any of the 11 in the radius.
Mm-hmm.
Some of the complexes had none.
Right.
The complex at issue, I believe, was highest or second highest.
Were you testifying on behalf of the defendant or the plaintiff?
Plaintiff.
And?
So the comparison clearly showed that of all complexes in the area, and I'll have to reread the opinion,
mm-hmm.
this one was at or near the top for the most violent crime of any complex in the area.
Right. And you didn't perform that analysis here?
Correct.
Sure.
There's no violence at this property.
You don't consider murder violent?
You mean the incident itself?
Right.
No, I'm looking at prior crimes.
Right.
So that was an analysis of prior predicate crimes, not the incident in question.
And you don't consider the burglaries or kicking in someone's door to be a violent crime?
It's a property crime.
Okay. Same for the firearm cocked, loaded, a serial number rubbed off?
Carrying a concealed weapon at McDonald's? That's not a violent crime.
Okay.
And it's not at the property.
All right. And the bullet fired through a window, you don't believe that happened, right?
Perhaps it did happen. There's no evidence that it happened. It's not validated by a police officer who responded to the incident. And that's pretty much what I need to know is, did a police officer validate this incident?
Do you recall testifying in a Board v. HMI Property Solutions?
This was the Judge Perdum case.
Right.
Yes.
And were you testifying on behalf of the plaintiff or the defendant?
Defendant.
And in that case, you looked at 13 complexes in a 1 mile radius, true?
I believe so, yes.
And you don't even know how many apartment complexes are in a 1 mile radius in the Surovec case, true?
What I will tell you is that I...
First answer my question.
Well, let him answer his question.
If I don't know the answer today, it's presumably because I did the analysis at the time and realized there wasn't sufficient density to justify a search. So that's all I can say.
Okay, so you're saying you performed the same analysis in Krista Surovec's case?
I typically do that. And the fact that there was no proximate property analysis in this case was probably a function of either that or the fact that you had no predatory violence on this property in 3 years. So to compare the level of predatory violence at this property to another complex in the radius wouldn't be necessary if the numerator is 0. In the Perez case, there was a clear predicate of violence at that property. And when I did the analysis, they were among the worst in the radius. At your property, there's no predicate. And maybe when I get out of here, I'll look electronically to see the density of complexes in the area, because if I didn't do it, that's probably one of the reasons. I just don't recall as I sit here. If that
one of the reasons would have been because you didn't feel like it was warranted here because of the lack of, what did you say, density?
Well, yeah, I mean, if there's, like in that Kimberly Board case, there's apartment complexes all around, right on top of each other.
Right.
And I don't recall that being a circumstance in this case. There might have been one other complex nearby, and as I read some of the reports that you present, I think there was, but a density of 10, 12, 14 complexes in the immediate radius, I don't recall that. And my site visit didn't reveal that I recall.
Now, in the board case, there was also continuous overnight security patrols, true?
The board case.
One
Yes.
before Judge Purdom.
Yes, there were, I think you had 2 armed guards at that property.
Right.
Crime still happened.
Do you think it's more likely to happen with armed guards or without armed guards?
You'll have to ask the offender.
Okay, so you have no opinion, no way of knowing.
It's case specific, depends on the offender.
Well, in our case, you can't ask the offender because you don't know who the offender is, true?
Well, that's one of the reasons I'm not opining about the ultimate issue.
All right, so you have no opinion regarding that in this case, true?
Whether the offender would have committed the crime if there was a guard on the property?
Armed guards, I think.
Armed guard? That's the jury's call. I'll point them to data and educate them and they'll make their decision.
Okay. There was also continuous camera coverage in that case, true?
Which case?
Board. The board case.
I don't think there was I think they had a camera at one time and then they took it down. I don't remember there being a camera on the building where this happened.
You recall that in Catherine Perez case, Perez's expert witness, Jacobs, testified that because the perpetrator in this case was unknown, he could not opine whether this particular perpetrator was deterrable. True?
Well, if you don't have the offender, you can analyze the crime, but you can't analyze the criminal.
And you can't make a determination as here whether it was deterrable, true?
Again, I've already said multiple times today that that's an ultimate issue opinion for the jury to deal with, and I'm not offering an opinion on deterrability.
In the Perez case, you also testified, quote, the jury heard testimony from Perez's expert witness Bruce Jacobs that in the 23 months prior to Patrick's murder, there were 18 violent crimes at 11 other apartment complexes within a 1-mile radius of Cross Timbers Park. True?
Correct.
So if there was other violent crime at other apartment complexes within a 1-mile radius of Nicholas Surovec's murder, that's something that you would need to consider. True?
Object to the form of the question. It's not the standard.
Not necessarily.
Okay.
I believe in that case there was an HPD officer, a Houston Police Department officer who worked at the property, who at some point provided access to that crime data to the property or had access to it. So that probably would have been the reason for the assessment. You know, he lived there, he worked there, the data's a keystroke away. So I don't know how to answer your question.
Well, you were representing the plaintiffs in that case, and you're representing the defendants in this case. Does the fact that you were representing the plaintiffs in that case and the defendants in this case have anything to do with your not taking into consideration criminal activity at other apartment complexes like you did in the Perez case?
No.
You advertise your work on More Law, Lexipedia, is that right?
No, sir.
Okay.
If they're advertising me, I'd like to know that.
Okay, here you go. Mark this as exhibit. Thank you. Exhibit 15. More Law Forensic Expert Directory listing for Bruce Jacobs, PhD.
Do not authorize this.
Okay.
So this is not something I authorize.
Okay.
I'm going to do any advertising.
Have you read a study conducted by Liability Consultants, Inc. of Sudbury, Massachusetts?
Maybe.
Okay. The study of more than 1,000 premises security liability lawsuits over a 10-year period. Does that ring a bell at all?
Not really.
Okay. Do you agree that because garages and parking lots contain valuable vehicles and their contents, plus the car occupants who also represent potential victims, both are frequent favored hunting grounds for robbers and thieves?
It depends on the setting. And it depends on the offender. But just like anywhere else, I mean, criminals, they're going to find a place to do their dirt. And sometimes it's parking lots, sometimes it's not.
So your answer is yes.
I think I qualified it.
It's a qualified yes.
I'll stick with the answer I gave.
So is it a qualified no?
Object the form. Answer the question.
I'm not going to repeat my answer. Sorry.
CCTV stands for closed circuit television. True.
Generally speaking.
Right. And there was no closed circuit television in the parking deck where Nicholas Surovec was murdered. True?
I think you asked me that many times, and yeah, the answer is the same.
The answer is there was not. True. You agree that uniformed security officers on continuous patrol of all the levels of a garage can be a significant deterrent to criminals and provide reassurance to customers and employees?
They can provide reassurance, and in terms of deterrence, it depends on the offender.
And in this case, you're not opining, or you don't have an opinion about the deterrability of Nicholas Surovec's murderers. True?
I've stated my 3 opinions and all the subpoints, so if that's what I said, that's what I said.
You agree that a patrol tour tracking system should be used to ensure that all patrolling officers are, in fact, patrolling as required?
It's nice to have it. I don't think it's required. It's nice to have it, sure.
All right. You mentioned earlier, I think, that you may have some notes in some of these depositions. You mind just telling me if there are any notes?
Just on top.
Okay.
So I took a few notes on your client's deposition, and
property manager.
Oh, in terms of the writings on the top page, yeah, those are just descriptions of who those people are.
Okay. What does this say for Denise Holstein? I'll just read them.
All of them?
What you wrote on them? Yes, please.
Roxy Miller, property manager. Denise Holstein, training director for apartment complex company. Joanna Oswald, manager, leasing agent at the property 06 to 08. Barbara Troiani, property manager before Joe Oswald, 0304. Brendan Boland, maintenance head, January 05. Did not live there at the time. Claudio Hammer Ramirez, maintenance man employee since 9/07. I think he's a groundskeeper. Florent Turmel, maintenance man 04 to present. Christina Lawal, assistant manager at the property 06 to 10. Robert Savoy, head of Crown Security. Drew Jackson, area manager, Crown Security. Sally Leonard, Crown Security corporate rep. Ruben Hurtarte, security guard at the property, appeared to work after the incident. Jimmy Browner, Crown Security guard, 2 months in 08. Thomas Walton, Crown Security district manager, and then Mr. Gross, 1 and 2.
And this, it looks like there are 3 pages of notes from Exhibit 4 that we haven't covered. You mind just telling me what those are?
Oh, these are just random notes from various documents. I think we've discussed most of this today.
All right, anything in here that we haven't discussed? I can't. Would you just read that?
This is security guard in one parking garage, can't see the other. That's Drew Jackson, page 124.
And what's the significance of that note?
Oh, I guess Mr. Gross was saying that he could, but the Crown Security Director said that they couldn't, so I didn't understand
Okay.
that. But the Crown Security Director is saying you can't.
All right.
And then I guess I took a few notes on the plaintiff expert.
All right. What are
It
those?
says perimeter fence. I guess he testified the perimeter fence has no part in the subject incident, page 42. He's got no opinion on causation, page 47. Gate arms don't prevent pedestrian traffic, page 47. Can reduce security if the crime can reduce security if criminal behavior goes down or at particular times of the year.
What's the significance of those notes regarding Jeffrey Gross's?
What's the significance? I mean, not for my opinion. It's just kind of interesting to me, I guess.
Do you disagree with what you wrote there?
Do I disagree with it? No, I'm just writing down what he said.
I know. Do you disagree with his opinions and the
All of
notes
his-
that you've taken?
Excuse me, all of Jeff Gross's opinion?
Good, you can answer.
No, I just wrote down these I guess, little data points. It's not a comment on his entire deposition. Just interesting comments. I'm not here to criticize another expert. Just those are comments that I wrote down that he said.
Right.
It's
Do you
just
agree?
descriptive.
Do you agree with Jeff Gross's opinions regarding physical security?
Do I? Well, what part of physical security?
All of it.
Well, object to the form of the question. Mr. Gross gave hours and hours of testimony and opinions.
Yeah, I mean, he has 2 volumes, 7 hours. I can't answer that question.
You think the physical security was adequate?
I've said my opinions today. I mean, I don't think I'm gonna,
Well, the question is,
5 o'clock,
you think the physical security was adequate? That's the question.
I'll just refer back to my original opinion that the overall crime prevention posture at the property was adequate and reasonable relative to the risk of this robbery homicide.
All right.
So that's what I'll say.
So
So
that's a
again, these are
yes.
just points that he said that I wrote down. It's just describing what he wrote. That's all it is. Or describing what he said.
All right. This.
This is just random notes about why the posture was adequate and reasonable. So these data points that I've already talked about many times today. No robberies, no predatory gun crimes, no gun-involved injury crimes, no predatory assaults, no escalation. Subject incident was not escalation. And then in mid-July to October, you had 1 auto burglary. So we've already talked about that at length. Crime scene photos show a packed garage. The fenders can hide anywhere and emerge from nowhere. That was getting me to think about whether, you know, a guard patrolling this garage or the other garage would have been able to interdict these guys, assuming that was their job. Their job was just to observe and report. And, you know, I saw that garage. I mean, the way they conducted themselves clearly indicates that they're not against hiding and emerging from nowhere when the time is right. That's exactly what they did from your client's testimony. And then great lighting. You know, lighting was outstanding in the garage when you look at the pictures.
All right. Any other opinions that you haven't shared with me today?
Again, I mean, maybe you asked me something down the road at trial that I haven't responded to today, but I've tried to give you my opinions and when you asked the question, and I've tried to give you the data points that support my opinion, so I think we've covered it.
All right, that's all I have.
We're concluded.
Going off the record is 5:05.